masks at all times. The Secretary will read the first order of the day.
Consideration of report of Standing Committee on Finance on rates and monetary amounts and amendment of revenue bill and amendment of revenue laws bill.
Thank you very much. I will now get advice from the Chief Whip of the Majority Party. Oh, okay. It is the first to the third. Sorry, ma. The first to the third orders. Sorry.
Consideration of report of Standing Committee on Finance on Taxation Laws Amendment Bill, and consideration of report on Standing Committee on Finance on Tax Administration Laws Amendment Bill.
Thank you. The Honorable, the Chief Whip of the Majority Party.
Thank you very much, House Chair. House Chair, I respectively move that the 3 money reports be adopted by this House. Thank you very much.
Thank you very much. The motion is that the reports be adopted. Are there any objections? No objections, agreed to. Can you read the 4th to the 6th orders?
First reading debate, rates and monetary amounts and amendment of revenue laws bill. First reading debate, taxation laws amendment bill, and second reading debate, tax administration laws amendment bill.
Thank you very much. I will now defer to the speakers list and call on the chairperson of finance to give us the report. Honorable Maswanganya. Is Honorable Maswanganya on the platform? Honorable Maswanganya.
Chair, he's trying to connect, but he's getting disconnected. I don't know how to deal with it now.
We have to give a short period to allow that. Can ICT please allow Mr. Maswanganya to come in? Help him to come through for us.
Thanks, Chairperson. I'm now connected.
Thank you very much, and thank you, ICT, for assisting. You may proceed, Chairperson.
Thanks very much, Chairperson, honorable members, colleagues. I hereby present the report of the Standing Committee on Finance on Tax Laws Amendment Bill B27-2020, Tax Administration Laws Amendment Bill B28-2020, Rates and Monetary Amounts and Amendment Revenue Laws Bill B26-2020. The Tax Administration Laws Amendment Bill, Rates and Monetary Amounts and Amendment of Revenue Laws Bill, and the Tax Laws Amendment Bill were tabled by the Minister of Finance, Honorable Mboweni, together with the medium-term budget policy statement. Before tabled to Parliament, National Treasury and SARS hosted workshops with stakeholders. The committee conducted public hearings on the bills on the 7th of October 2020. The committee also considered oral submissions from the public. TALAB, that's the Tax Administration and Laws Amendment Bill. TALAB is a Section 75 bill in terms of the Constitution dealing with tax administration issues. The object of the bill is to amend the Estate Duty Act 1955 to make textual corrections, amend Income Tax Act 1962 to delete obsolete wording, amend Customs and Excise Act 1964 so as to make technical corrections, amend the VAT Act 1991 so as to substitute the requirement to submit a return with obligation to obtain, complete, and retain the form prescribed by the Commissioner. Amend Skills Development Levies Act of 1999 to provide that the Commissioner may refuse to authorize a refund if a return is outstanding. Amend the Unemployment Insurance Contributions Act of 2002 so as to provide that the Commissioner may refuse to authorize a refund if a return is outstanding, and amend the Tax Administration Act of 2011. Rates and Monetary Amounts and Amendment of Revenue Laws Bill. It is a Section 77 bill dealing with national taxes, levies, duties, and surcharges. The key issue raised during public hearings was on the increase of excise duties on tobacco. Illicit tobacco trade increased during the lockdown with severe impact on the legal tobacco industry and revenue collection. The committee calls upon the law enforcement agencies to clamp down on illicit tobacco trade. The Minister of Finance also addressed a letter to the committee to request the technical corrections to clause of this bill in line with Section 14 of the Money Bills Amendment Procedure and Related Matters Act of 2009. The committee agrees with the technical amendment proposed by the Minister. Tax Laws Amendment Bill B27 of 2020. This bill is a Section 77 bill in terms of the Constitution dealing with national taxes, levies, duties, and surcharges. The committee agrees with the technical amendments, correcting the date of the coming into operation of Clause 17 provision. The committee has adopted the report in this regard with amendment. There are challenges in regard to the collection of revenue, Honorable Chairperson and colleagues. In terms of the economic outlook, we present this report against the backdrop of rising unemployment, rising inequality, increasing poverty rate. COVID-19 pandemic is leading to a situation where dreams of our liberation could be eviscerated. The pandemic has deepened the depression and will result in 3 years of declining GDP. According to the UNDP, it can take 5 years to reach 2019 levels of the GDP, and the collateral damage could be with us for the next decade. We are witnessing declining tax revenue. Collection from 2019-2020 financial year was quite very low. In 2019-2020, the budget review has estimated that gross tax revenue that will be collected will be 1,358 billion. This target was not met as the SARS COVID-19 pandemic, and that resulted in a sharply decline of the tax revenue. SARS reported that VAT collected was 6.7% lower than the same period in 2019-2020. Other specific and key challenges in regard to the collection of revenue are as a result of personal income tax, which has gone down due to retrenchments and cuts on wages. A weaker impact outlook, which has reduced VAT and customs expectations. A sharp reduction in consumption had lowered VAT collection. A sharp reduction in company tax due to business closures and low profitability. Downward adjustments in specific excise duties associated with a longer than expected tobacco ban. These are some of the challenges, Honorable Chair, that have led to the decline in the tax collection of revenue. To a certain extent, the stimulus package announced by the President mitigated against the worst case scenario. The tax relief measures provided temporary assistance to businesses and households during lockdown. This intervention offered a combination of cash flow relief through tax deferrals and direct support through increased incentives to retain lower income employees and reductions in payroll taxes. In conclusion, Honorable Chair, SARS and National Treasury should respond to these challenges outlined above by vigorously implementing a sustainable revenue enhancement strategy. SARS has to continue to come up with innovative ways to improve its operations and services to meet current and future revenue needs. Honorable Chairperson, I move for the adoption of the report. Nakez.
Nakenza Nkofu, Iko. Honorable members, the next speaker on this is the Honorable George.
Thank you, Chairperson. Taxpayers have a social contract with government. They pay their tax and government distributes it in the form of services delivered to the people. When government collects tax from hardworking citizens and fails to deliver service, that fundamentally erodes the social contract. The process of distribution is notoriously difficult and often referred to as a leaky bucket, where money collected to deliver service to the people does not get used for that purpose. Our public financial system is riddled with corruption. And last year, the President mentioned at a summit in London that the amount of money siphoned off the coffers of the state through corrupt means runs way beyond 500 billion rand, and that some have suggested that it could be 1 trillion rand. Under these circumstances, there's little wonder why honest individuals and companies feel unfairly treated when they are subjected to penalties for late submissions and payments, while others are literally stealing the money they pay without any consequence. SARS should concentrate on catching the real tax evading criminals. The taxation laws are complicated and have been constantly evolving over the past 70 years and fairly rapidly since 1994. Although there has been much discussion on simplifying the laws, little progress has been made, and it is increasingly difficult for individuals and small business owners in particular to file their taxes without the assistance of paid professionals. The auto-assessments generated by SARS have created some confusion amongst taxpayers who are unaware that this assessment is sometimes incorrect and can be disputed. The Minister's recent medium-term budget policy statement has highlighted the very serious public financial crisis that our country faces. Despite the reality of a significant reduction in expected revenue resulting from lower economic activity, there is nothing in the taxation laws amendments that seeks to provide any incentives for entrepreneurial activity. Section 12J of the Income Tax Act was designed for that purpose, but failed to initiate the type of entrepreneurial activity that Treasury sought to promote. Rather than shut down this incentive scheme, government should consider other creative ways to provide relief in the sector of our economy, especially now as the economic impact of the COVID-19 pandemic starts to bite really hard. There is clearly no sense of urgency from government in responding to what is becoming a full-blown depression. Instead of taking steps to ease the personal financial difficulties faced by hardworking South Africans, government has made life more difficult. In particular, the changes to the rules on financial immigration will cause hardship to those who, through various personal circumstances, are moving abroad. Previously, immigrants were able to withdraw their retirement annuities and the balance of preservation funds where they had already made one withdrawal on conclusion of the process. Under this bill, a South African who has completed the financial immigration process will need to wait for 3 years before they will be able to withdraw these funds. Government claims that this is to avoid abuse by individuals who claim to have financially immigrated but haven't, and thus access their pension funds. Government is working on the wrong problem. Individuals who have chosen to immigrate desperately need the money to settle abroad. especially given the dismal performance of the rand exchange rate. This, the direct result of government mismanagement of our economy and incoherent economic policy. The actual cause of the so-called abuse is that individuals are desperate to access at least a portion of the retirement fund assets in the current economic crisis. I have proposed a private members' bill to permit pension funds to offer loans to members, especially self-employed members of retirement annuities, to alleviate this difficulty. Government desperately wants to hold on to captive pension funds because it somehow believes that trustees of pension funds will invest in its infrastructure projects that it believes will magically generate jobs that government can claim credit for creating. Failing this, it will force them into investing into prescribed assets to the benefit of government and its cronies. Instead of trying to figure out how it can access the 4 trillion rand that belongs to pension fund members, government should ask what can be done to enable hardworking South Africans to leverage their own money for their own personal financial benefit. The retirement fund industry also needs to offer creative solutions. Doing nothing is not an option. That is the problem that government should be working on. It should be considering how to give power to the people rather than taking it away. Government somehow believes that the state-owned enterprises will miraculously become viable, and if a bailout is given a different name, then it isn't a bailout. If government denies access to funds that belong to a member for 3 years, even though that money belongs to the member, what is that other than a prescribed asset that must remain invested, although it is not in the member's best interests? Call it what you like. Locked-in pension money is a prescribed asset. Government is also making life difficult for salaried employees who currently have access to bursary deductions via their employer's payroll. Although this resulted in a tax benefit to the employee by making the payment from their pre-taxed income, the DA believes that tax relief on education is beneficial for the future growth of our economy, and that current tax relief received should be expanded rather than eliminated. We welcome the commitment from government to combat the illicit tobacco industry, given the impact this has on tax revenue, and do not oppose the increase in the taxation on tobacco products. Government must, however, remember that it has caused the spike in the illicit tobacco trade. Its nonsensical ban on the sale of tobacco products during the initial lockdown period provided an even more fertile ground for the illicit tobacco trade to flourish, no doubt to the benefit of politically connected cronies. We also welcome the slight reduction in transfer duty, amendments to primary and secondary rebates, and tax-free savings account annual limits. These tweaks will make no difference to the fiscal framework, where indicators are all pointing in the wrong direction. Debt service costs are the fastest growing item of spending. Since 2008, the real cost of the public sector wage bill has risen by 51%. Our economic growth will contract by at least 7.8% this year, and output is only expected to return to pre-pandemic levels in 2024. 11.1 million people are unemployed. Although these are extremely difficult times, taxation laws can be an effective instrument in encouraging an acceleration in economic growth. They reflect the economic policy of a government and deliver the incentives for investors, small businesses, and entrepreneurs to thrive. There is no evidence in the laws on the table before us today that government has even the vaguest idea of how to stimulate economic growth. Essentially, we have a simple choice of state ambition versus giving power to the people. We need to see incentive measures that will facilitate growth in our economy and lead to a credible path of debt reduction over time. We need to see support for small businesses and entrepreneurs that will take the focus off endless bailouts to state-owned enterprises and onto the real drivers of economic growth. Until then, the social contract will continue to erode. We will not support the bills. Thank you, Chairperson.
Thank you. I don't have a name for the EFF. EFF?
Thank you, House Chair. I'll do the debate on behalf of the EFF.
Thank you. Proceed.
House Chair, the Rates and Monetary Amounts and Amendment of Revenue Laws Bills, Taxation Laws Amendment Bill, and Tax Administration Laws Amendment Bill are bills tabled by the Minister of Finance as part of the medium-term budget policy statement. These bills are amended regularly because they adjust the rates of taxes that workers and companies must pay to the South African Revenue Services. These bills also make administrative amendments to various pieces of tax legislation such as Estate Duty Act, Income Tax Act, Custom and Excise Act, Value Added Tax Act, Skills Development Levies Act, Tax Administration Act, and other tax-related matters. While the key proposal of the amendment bills was the removal of a requirement to prove intent from certain statutory tax offences, the immediate and disturbing fact is the inability of either the Minister, the National Treasury, or SARS to competently address the continuing and widening revenue shortfalls. Since his appointment, the Minister of Finance, he has not put any practical and believable steps to meet the revenue targets which he has set himself. In 2019, the revenue was lower than estimated by 15.4 billion rands. In 2020 February, the revenue was lowered by 63 billion rands than the estimated revenue at the time of the 2019 budget. This was before the COVID-19 pandemic, so no one must come and mislead us by saying it is due to the impact of COVID-19. The current medium-term budget policy statement just revealed that the gross tax revenue is expected to be lower, to be 17.9% lower than collection in the previous year, and the tax to GDP is declining substantially. There are practical proposals which we have made in the past that can assist to boost the gross tax revenue and prevent the 17.9% lower than estimated revenue this year. And we can do this without increasing taxes paid by workers, fuel levy, and other forms of taxes. There's enough evidence, Chair, that South Africa and Africa loses billions in illicit financial flows, and almost all sectors from manufacturing, financial services, mining, agriculture services, construction, and transport are all involved in some level of illicit financial flows through base erosion, profit shifting, and more pervasive forms of corruption, money laundering, and racketeering. This affects foreign exchange revenues, affects asset prices, lower taxes revenues, and ultimately reduce the money available for building schools, building hospitals, clinics, water infrastructure, sanitation, eradicate pit toilets, and building of decent toilets for the learners. We maintain as the EFF that we need a full judicial commission of inquiry to receive evidence on illicit financial flows dating as far back as 1994. This is the only way we can begin to deal with illicit financial flows aggressively, and we must target multinational corporations. We must urgently find a way to tax e-commerce businesses. This should form a substantial part of the revenue stream for the country. We must tax Uber, Amazon, Google, Zoom, Microsoft, Apple, and all other cloud-based transactions. We must tax the rich, including tax of lands that lie fallow. We must increase corporate income tax instead of the personal income tax. We must get proposals on how we can incorporate the informal sector, including businesses based in rural areas, to start paying tax to broaden the tax base. This will require tax education and improved administration capacity and integrity. We must also consider taxing churches, given that pastors seemingly there is more money than what pastors know what to do with. We must get a functional cross-agency task force that will include National Treasury, SIU, Financial Intelligence Sector, SAPS, SARS, Central Bank, and the NPA. Since the minister's announcement in his previous speeches that there is a cross-agency team, we haven't received any tangible report to suggest that this is actually a functional team. Overall, Chairperson, we must agree as a matter of principle that we cannot continue to increase workers' taxes because it is no longer practical. Price of food has gone up, price of school fees has gone up, housing and cost of running a business has gone up. Workers have had enough. We reject this report as the EFF. I thank you, Chair.
Thank you, Honorable Maudre. The Honorable Buthelezi.
Thank you very much, Honorable Chairperson. Fiscally, 2020 has been a difficult year for our country. Before the COVID pandemic, we were struggling economically, and COVID-19 had made things worse for us. SARS recorded devastatingly low revenue collection over this period because many South African companies and individuals were unable to generate the expected income. Imports decreased, and we saw a significant decline in VAT. Due to such sudden loss of income for over 2 million South Africans, our tax base has notably decreased. As the period for tax filing just closed, it is likely that we'll continue to see this downward trend. The reasons are why the amendments we are debating today important. The rates and monetary amounts and amendment of revenue law bill extend relief to property markets, which was hit hard by the pandemic. Other than COVID-19 related matters, the bill seeks to increase carbon tax for greenhouse emissions. This is a critical contribution to our fight against the global warming and climate change. The IFP believes that a firm stance with severe punitive measures must be taken against companies that continue to ignore legislations regarding greenhouse and emissions. The Taxation Law Amendment Bill recognizes the need to secure legislative loopholes that allow dishonest entities and persons to evade their tax obligations. And the Tax Administrative Law Amendment Bill addresses the need to appropriately respond to tax-related offences such as non-compliance, evasion, and hindering the work of a SARS official. While we must approach such conduct with the seriousness it deserves, caution must be exercised. Honourable Chairperson, we can't continue to read stories about billions of rands which leave our borders unaccounted for. The IFP urges the practice of fairness and reasonableness in response to tax-related offences. We encourage the strengthening of our tax systems, especially in such uncertain times. Our taxes fund important social and economic projects which affect the day-to-day lives of millions of our people. And lastly, Honourable Chairperson, this government must focus its attention on rooting out the rot, which is corruption in all spheres of our administration. It is nice to play with other people's money, but it is not nice when that money dries up and is stolen. Let's spend the taxpayers' money in a responsible and sustainable manner in which we can see the reward for which it was intended to deliver. We must get this balance right as our country to continue keeping the lights on for our people and for us to continue to put food on the table. The IFP supports the bill. Thank you.
Thank you. The Honourable Vessels.
Thank you, Honourable House Chair. House Chair, these tax laws are technical in nature and largely aimed at increasing government's revenue. But no law will improve government's revenue stream. Without economic growth and a conducive environment for the private sector to operate, invest, and create employment, the tax revenue of this country will get less and less, whilst the burden on government to provide social relief and services will become more and more. The introduction in this legislation of a 3-year rule for those who wish to withdraw their pension upon immigration will result in hardship. But it is not something that a government can do with legislation to force South Africans to not immigrate. And it's very sad that it has come to that. There's no reason for this introduction of this rule, and National Treasury cannot explain a real explanation and reason for this introduction, other than keeping money in South Africa, preventing people from immigrating. But Chairperson, government must put its aim at preventing people from immigrating by rather creating an attractive country where people do not want to leave from, where there is economic growth, where corruption is something in history and is not a daily pandemic and a daily occurrence. Chairperson, increasing excise duties, increasing taxes is not the solution. We must be careful that the actual objective of these duties will not achieve its objective, but will have unintended consequences of further deteriorating economic growth. Voorsitter, die regering moet belasting verdien. Hy moenie net belasting in nie. En dit is die klimaat waarin ons tans is. Die regering maak wetgewing, maak dit strenger, verhoog belasting en wil die wat belasting betaal net verder en verder aanslaan en vervolg indien hulle oortree. Maar wat van die waarde van daardie belastinggeld? Is daar waarde? Daar is nie. Want geld word gemors, geld word wanbestee op alle vlakke van die regering, korrupsie vind plaas en daar's verkeerde prioriteite. No act, no legislation will solve that. There must be a mind shift, there must be a new commitment to better governance. Die EFF dink dat geld uit die hemel uitval, dat maatskappye sakke vol geld het en dat hulle net belas en belas moet word. Wie dink die EFF betaal die werkers se salarisse? As belasting verhoog van maatskappye, dan kan hulle nie meer salarisse bekostig nie. En dit het 'n negatiewe impak. Die privaat sektor moet gekoester word en nie die vyand gemaak word nie. Want dit is die probleem op die oomblik. Tussen die regering, die regerende party, die ANC, en hulle maatjies die EFF, is die privaat sektor en die wat eintlik verantwoordelik is om hierdie ekonomie te red, die heeltyd die vyand. En dit is hulle wat gekoester moet word en nie die heeltyd vyandig hanteer moet word nie. Moenie net na wetgewing kyk nie, maar kyk na hoe die geld bestee word en of belastinggeld op die einde van die dag verdien word. Ek dankie.
Dankie. Help ons. Thank you. Honorable Swart, you are the next speaker.
Thank you, House Chair. House Chair, the ACDP fully appreciates the very precarious state of public finances that we are enduring at the time, with revenue projections down by 312 billion rand. However, it's important to note that certain of these projections were already done prior to COVID-19, and it's just been aggravated to this extent with COVID-19. And that, as we've said before, was largely due to state corruption and looting that took place. Now, the ACDP is on record to say that SARS has certain powers to recover those billions of rands, and we would urge SARS to make use of the powers that they have to pursue those persons that owe billions of rands and those billions of rands that are sitting across the world. We would also, having looked at some of these amendments, share the concerns that other members have expressed about the changes to the 3-year rule, the changes to the financial immigration laws. These are problematic. These funds are needed for those that choose to settle overboard, and they belong to the member, and we see no reason why those members should not have access to those pension funds. One of the most controversial aspects that was raised during the issues was the Section 234 of the Tax Administration Act. Now, bear in mind, we've just said, as the ACDP, that there are billions of rands that can be collected. Now what we are seeing, and myself expressing my view as a lawyer, is a very deeply concerning aspect, and that is removing the requirement of criminal intent for certain offences. Yes, we do see that the more serious offences still will require mens rea. However, those offences which are the non-compliance offences will be purely negligence, and I believe that that is problematic. And yes, the National Treasury did set out their arguments. They quoted various court cases in this regard. But what is of concern to me is that the offence has a penal provision of 2 years or a fine, 2 years imprisonment, and that existed before this amendment was added, which removes the intent, the criminal intent provision. And yes, whilst the judicial officers will have the discretion to impose fines, it is deeply problematic that now if you negligently act and you negligently fail to submit a tax form, that you can then be held criminally negligent. Now remember, National Treasury, in its submission to support this, quotes from the Constitutional Court saying that sufficient leeway ought to be afforded the legislature to determine the appropriate level of culpability. That is our job, and I believe that we've erred in removing specific intent and mens rea requirement for these criminal offences in terms of this taxation legislation. I thank you.
Thank you, Honorable Swart. I don't have a name for the UDM. Are you there, UDM? No. ATM? I don't have a name too. ATM? No. The Honorable Sheikh Imam, NFP? Honorable
Chair, is it not good party? Is it not good before NFP?
I don't see the good here. Maybe they've
Okay.
given a notice that they are not.
Okay.
Yeah.
Thank you very much, House Chair. Thank you very much. The South African Revenue Services is a critical institution more than ever before. The Minister told us in his medium-term budget policy statement speech that we are today fiscally at a moment not too dissimilar to 1994, when we had to deal with the devastation of visited upon our public finances by the apartheid regime. However, in 1994, government debt was 46% of GDP. The debt was reduced to 26% by 2009. But now government debt is sitting at 81.8% of GDP. It becomes very clear that the larger the debt is related to the country's economic activity, the harder it will be to pay it off. Now, Honorable House Chair, the National Freedom Party welcomes the transfer duty and the proposal to increase the monetary value for transfer duty on property. In fact, this relief in the property market, the changes progressively affect other property values, providing similar relief as well. The National Freedom Party welcomes the excise duty increase in tobacco and alcohol, and particularly because this will reduce consumption of tobacco and alcohol, reduce the burden on the health sector, improve productivity in the labor sector, and also reduce accidents and things, where 26% of them are alcohol related. Some of the matters that I think we need to deal with is the illicit financial flows, multinationals showing losses in South Africa, profits offshore. These are some tax avoidance. What I think SARS needs to do, which is not happening in the country, it's not increase taxes, but get more people to pay taxes. And one way is to link the South African Revenue Services with the local authorities at municipal level who issue licenses to business and employ people together with the labor department and things, so people can become more compliant and more people could be paying taxes. Many of these people are not even registered. They have businesses, they're making profits, they have people employed by them, and they're also claiming that 350 renters grant that we've provided. So the other issue is the issue of under-invoicing, particularly goods coming from China, where they invoice at a very low rate, and to try and avoid paying the correct taxes. Financial institutions that are being set up in South Africa, particularly where monies are sent abroad to family and friends and things like that, it's something that is being abused to a very large extent, and I think SARS needs to deal with that, because these people that are in the country, particularly foreign nationals, are running businesses, they are earning an income, they are sending money out of the country, but they're not tax compliant. And the thing is we should be leveling the playing field and making, like locals are paying taxes, that foreigners must also equally pay taxes. The 1,500 fine that was given for illicit tobacco was certainly not a deterrent during the COVID-19 period, because people were making 50 to 100,000 Rand profit per day on illicit sale of cigarettes, but paying 1,500 fine. And further, the Minister of Justice has said this is expunged from your credit record, your criminal record. So really, it was no deterrent whatsoever.
Honorable Sheikh Imam.
The carbon tax,
Your
we can
time
understand,
has
but the
now
problem we have, Honorable House,
Honorable
is that we increased
Sheikh Imam.
and put in sugar tax.
Honorable
But it was
Sheikh
never
Imam,
thank
your
you.
time
The
has
National Freedom
expired.
Party supports it. Thank you.
Thank you. AIC, may we confirm you are not on the platform? Thank you. COPE, Honorable Majisha is here. Honorable Majisha.
Thank you, Honorable Chairperson. For South Africa to achieve the required strong rebound in economic growth for the tax to GDP, many critical areas must be addressed. Whether government wants to accept it or not, it is a fact that South Africa has a lot of money, but the money the country has is used improperly due to the absence of proper plans or extreme levels of corruption that is there within the ruling elite. These two reasons are the main factors that led to South Africa not seeing any economic recovery since 12 years ago, that is in 2008, and shall actualize the expected debt increase to more than 5.54 trillion of GDP in the next financial year. Unless proper planning is done, debt shall grow and the country will never recover in this century. The in-year revenue collection shall never succeed unless quality jobs are created and workers receive a living wage. Only jobs and a living wage can avail tax contributions and remove South Africa from being a welfare state. As some of us may be aware, the status of such a state is not sustainable. Secondly, we need to reduce the SOEs. The majority of SOEs are useless, as they share mandates and are responsible. Despite their useless status, they are given billions which should be used for job creation and general economic growth. I must emphasize that the empirical evidence that prove their lack of importance is unquestionable. The intended extra financing for many municipalities in the country is at the moment unnecessary, given the incapacity by many local government structures and or municipalities to execute and or deliver what are their basic mandates. Local governments are given money but don't implement what they are supposed to because they do not know the basics of IDP. Local government and municipalities must be taken through IDP requirements for them to both know and understand the usage of taxes. We can't, as the people of South Africa, pay more, and therefore COPE does not support this bill. Thank you very much.
Thank you, Honorable Majisha. The PAC, are you there? No. Al-Jamal?
Honorable Speaker, we're not participating. Thank you very much.
Oh, he said that. Oh, okay. Okay, thank you, Honorable Hendricks. I couldn't hear clearly what he was saying. Thank you. We proceed. Honorable Morolong, ANC.
Ake go dumedisa modulasetulo wa ntlo kgethegileng. 3 weeks ago, we spoke on this very platform and bade farewell to an outstanding public servant, a dignified man, a gentleman of great repute, a decorated administrator, Mr. Kimi Makwetu. Surely we were unaware that death would strike where it hurts most and rob this nation of a noble man who served this government and his people with honor, passion, and rectitude. We convey our heartfelt condolences to his family, friends, and colleagues. We wish them strength during this difficult period. Honorable members, the President of the people of South Africa turns 68 years today. We wish the Commander-in-Chief of all armed forces, the President of the African National Congress, President Matamela Cyril Ramaphosa, renewed strength and good health on the occasion of his special day. One of the defining features of any state is its tax regime. For a developmental state, the regulation of a progressive taxation system in which there is inbuilt human solidarity, with the wealth supporting and crops subsidizing the poor, is both morally justifiable and underpin the ANC ethos towards taxation. It also denotes a redistributive system in which a country can gradually, over a period of time, move to far higher levels of an egalitarian socio-economic system. Neoliberal states use a regressive tax policy in which they seek to protect the wealthy lessen their tax responsibilities, and provide tax relief to companies so that they can accumulate capital at higher rates. Under such systems, it is the poor who generally carry the greatest burden. It needs to be said that in this House, there are those parties who, because of their class orientation, favor the regressive taxation system. For the ANC, generating high levels of revenue to address rising inequality and deepening poverty is a matter of policy. The manifesto of the ANC speaks to a microeconomic framework designed to support the commitments we made in the manifesto. This microeconomic framework is underpinned by revenue proposals, and hence today we will be passing 3 additional amendment bills in order for the state to generate additional revenue. Besides human solidarity and cross-subsidization, a progressive taxation seeks to ensure fairness in application of the system, and again today, the contradictions that have been raised in the application of various parts of our tax system are being corrected by the ANC government to ensure greater fairness. Having said this, and I listened to the submissions in our public hearings, the ANC draws a distinction between those who lobby for changes to the taxation system in order to continue on a path of greater capital accumulation and think that their only responsibility to the state is to pay tax. This is a reflection of lower levels of consciousness. Honorable House Chair, it must be our collective responsibility to build on the progressive taxation system, informed by the need to fund the economic reconstruction and recovery plan, to ensure that the vulnerable in our society are lifted up, that our people have decent houses, that they have running water, that they have decent sewer system, that they are able to access public transport and have food to support their families. So where does the philosophical orientation of our taxation system derive from? This is best described by a commission established by the ANC-led government to review the taxation system, following a period of evaluation by the governing party, that government was not extracting the true value of what should be accrued to it from the taxation system. It was further informed by the increasing need to generate revenue, to fund programs that address the historical legacy of unemployment, poverty, and inequality. The terms of reference for the Davis Tax Review Committee were to look into the role of the tax system in the promotion of inclusive economic growth, employment creation and development, and fiscal sustainability. The committee was tasked to take into account global economic considerations and in particular, the long-term objectives of the National Development Plan. For the ANC, there are issues that we have been long seized with and that require updated presentations to be made to the committee. The state is being drained on an annual basis at a level and extent that is completely unacceptable, and we have to be seen to be more decisive against perpetrators. Hence, we refer to base erosion and illegal forms of profit shifting. While we are conscious of the fact that Section 6 of the Income Tax Act has been repealed and Section 10 reviewed, for which the ANC government needs to be credited, concerns over the erosion of tax base of the Republic continues in the grotesque illicit financial flows out of the Republic. The United Nations Economic Development in Africa Report 2020 states that South Africa has received over 1 billion rand in stolen assets. What this means is that we are losing billions of rands per annum through illicit flows. This is the money that could finance our National Revenue Fund. Honorable members, in the 5th term of Parliament, it was this very committee that spearheaded the financial sector transformation path to deal with the transformation of the financial sector, a sector that is primarily responsible for illicit financial flows. In addition, the committee was targeting corruption and theft of state revenue. Whilst we acknowledge progress recorded by the various units set up in the state institutions, more resources must be put in this area. Whilst we are deeply concerned that debt levels are increasing, and it is this very revenue we are losing to the state that equally puts us in a weakened position. Parliament must, through its oversight, ensure that criminality that exists in the financial sector is punished. This is a sector that has been the greatest benefactor of our democracy. Whilst we have amended legislation in this regard, illicit financial flows continue. We must remind NEDLAC that they have not set up what we have asked for years, a financial sector summit. A financial sector summit. After Parliament processed the matter, and the ANC 54th National Conference explicitly expressed itself in this regard. NEDLAC cannot be found wanting on the transformation of the financial sector, which is meant to address class, race, and gender contradictions in capital accumulation post-1994, in addition to address the source of illicit flows out of the country. We are saying this mindful of the fact that we are losing this financial year alone 320 billion rand in tax revenue due to COVID-19. The ANC supports the 3 amendment bills. I thank you.
Thank you, Honorable Morolong. Oh, niyachwaga marbeni intimidate babulanga. Babulanga, ngapha, abantu abangapha, ngibo abavumelekile ukuchwaga, ukubetha izandla. Bangakuthuseli bathi ungazibethi, uzibethe. Ngiye. Siyaqhuba nje, the Honorable, the Deputy Minister of Finance will close the debate.
Thank you, Honorable Chair. Honorable members, please accept Minister Mbowen's apology, who has joined the President at the BRICS Summit. Honorable Chair, economic growth sets the necessary conditions for the ability of the state to generate revenue. As we have said on numerous occasions in this House, that the pre-COVID period experienced low economic growth, and COVID has simply worsened our economic growth problems. And these have negatively impacted on our tax revenue. Honorable members, it's worth noting that in the last 6 years, government introduced substantial tax increases to arrest the decline in the fiscal position. These large tax increases, which included higher income tax, higher wealth tax, and higher taxes on consumption, did not fix our finances, and it is possible that the tax increases might have depressed economic activity. In February this year, we broke this 6-year trend by not increasing taxes. We all agree that the country requires higher economic growth to create employment, generate additional tax revenue to fund social and economic expenditure. Unlimited tax increases dampen economic activity. This year was not the time to increase taxes. Otherwise, that would put the economy under even more pressure. Instead, we provided 2 billion in personal income tax relief to assist households in this difficult economic environment. And this was offset by the expected additional revenue from the carbon tax and a higher plastic bag levy. The personal income tax brackets and rebates were increased by 5.5%, where expected inflation was 4.4%, providing real tax relief. Since the impact of COVID, inflation is expected to come down further. For those who've been lucky enough to retain their incomes, if you did not get an increase in income this year, then at least your tax bill will be lower. Even in these difficult times, government has tried to encourage savings by increasing the annual limit for tax-free savings accounts to 36,000. Members of the Standing Committee on Finance would have noticed the number of submissions from the tobacco industry on the increase in the excise duties on tobacco. In line with other adjustments, the increase in excise duties on tobacco in February was set at the level of expected inflation. Government needs to consider the harm done by cigarettes, which create a number of other costs on our society. We recognize the impact on the industry from the COVID-related restrictions on tobacco sales, which is why tax deferrals measures for the industry were introduced in the previous tax bills. However, the call to stop all excise increases on tobacco products and reduce the real amount of taxation for this product does not adequately consider the wider health and economic impacts of these products. The apparent scale of illicit tobacco is the real scourge in this story. We welcome the stance of the Standing and Select Committees on Finance that more needs to be done to combat illicit tobacco. We cannot let brazen illegality from manufacturers and distributors of illicit tobacco to continue. I will follow up with the SARS Commissioner to ascertain what progress is being made in this regard and other issues that our colleagues have raised. The Standing Committee would have also noted there were a number of changes to the initial draft legislation, which shows that the consultation process is valuable and hopefully leads to a more effective tax regime. For example, changes were proposed in our attempt to modernize the tax system for contract mining. Yet, after much discussion, those amendments have been withdrawn and will be considered from a more holistic perspective for possible future proposals. There are a number of anti-avoidance measures in this bill, and although some of the measures have been tweaked, almost all of those proposals have been retained. The anti-avoidance measures are aimed at reducing the gains that businesses and individuals play to reduce how much tax they pay. We must and we should do so. We must combat complicated financing structures that are used solely to avoid tax, which undermines the fairness in the tax system. This is especially worrying when many families are struggling through this crisis. In conclusion, Honorable Chair, the COVID pandemic has overshadowed many things this year and will be counting the cost of its impact for many years to come, starting with
No, this one's a price.
revenue shortfall of 112 billion this year. Despite this, we must push forward with the changes needed to recover strongly and improve the long-term prospects for economic growth in this country. The tax system is an important equation in this regard. I would like to thank both the Chair, Honorable Joe Maswanganyi, and other members of the Standing Committee of Finance for their consideration of these bills. Thank you very much, Honorable Chair and honorable members.
Nakhensa tata. Honorable members, that concludes the debate. Are there any objections to the rates and monetary amounts and amendment of revenue law bills being read a first time? Yes?
House Chair, please note the objection of the Democratic Alliance.
The DA's objection is noted.
Honourable Chairperson, the Freedom Front Plus would like to call for a division.
The Freedom Fund Plus would like to call for a division. That means I'm not going to take any other objection because the division has been called. The division having been called, I will allow 5 minutes for the bells to be rung. How many do we need to pass it? How many do we need? It's 200. One? Oh, okay. The majority, yeah. Okay. I doubt. Thank you very much. Honorable members, we have already established the quorum with the NA table, and we do correct to go on with the vote. So party whips will then be given an opportunity to confirm the number of their members present and indicate if they vote for or against. And a member who wishes to abstain or vote against the party vote may do so by informing the chair.
Chair.
Yes, Honorable Ntangwini.
Chair, I still haven't received my figures from IT. If they can please send the EFF's attendance on a visual system. We still haven't received it.
Okay, I may assist you from our table here if they can assist me, but I think the IT is also listening. Are you able to assist from the table? Can you just check how many they are? But I hope ICT will. Okay, Ma'am Tlangwini, they are looking into that. I think you will be assisted. Honorable members, the question before the House is that the rates and monetary amounts and amendment of revenue bills be read a first time. The voting will now commence. Are we able to start, Secretary table? Can we start? Okay. We will start with the ANC.
Thank you very much, House Chair. House Chair, the ANC in plenary in the NA chamber were 1818. On the virtual platform, ANC has 153, totaling up to 171, and we vote in support. Thank you.
Thank you very much. The DA?
Thank you, House Chairperson. In the physical House, the DA has 13 members. On the online platform, we have 47 members. That gives us a total of 70 members voting against.
Thank you. Have you been able to assist Ma'am? Okay. Oh, okay. Honorable Ntlangwini, Mrs. Mkalipi has got the numbers because the table staff do not have your phone number now, but the number to advise that we have is 32 from the virtual platform. And
House Chair?
Yes.
I'm terribly sorry to interrupt, but House Chair, I realize I've just made a mistake. It's 60 members in total for the DA, not 70.
Oh.
My mistake, and I apologize.
Thank you for that. Thank you. Are you ready to give us now, Ma'am Tlangwini? Ma'am Tlangwini? Okay, let's pass.
Chair?
Yes, ma'am.
Just pass us, we will come back, Chair.
Okay. The IFP?
Thank you very much, Honourable Chairperson. We are 11 members on virtual, all in favour. Thank you.
Thank you. The FF Plus?
Yes, thank you, Chairperson. 2 members in the House, 8 on virtual, total 10 voting against.
Thank you. The ACGP?
Thank you, House Chair. The ACDP has 3 on virtual, 1 in the House, and we vote against. Thank you.
Thank you. UGM? They have not logged in today. ATM? Nobody. Good? No one. NFP?
No.
Is good?
Thank you, House Chair. The National Freedom Party has 1 on virtual and in support. Thank you.
Thank you. AIC? Not there. COPE?
Thank you, Chair. The 2 members in the House from COPE vote against. Thank you.
No, I saw the Honorable Lekota was sitting there. I'm sure she has. Where is she now? Honorable Madisha, we
Yes.
agree with what you are saying, but the rule says if
Okay.
if we lock the doors for voting,
Okay.
those
Yeah.
outside are not counted. Thank you.
All right, no problem.
So it's 1 for COPE, and it
Okay.
is voting.
Against.
Thank you. Thank you. PAC? Niemand. Al-Jama?
Al-Jama has 1, Honourable Chair, and we vote in favour.
Thank you very much. The EFF?
Thank you very much, House Chair. We have 1 member in the House and 32 on the virtual platform, and we are voting against. Thank you.
Thank you very much. I will just await the outcome. Thank you. Honorable members, the total number of members, both in the House and on virtual, that voted is 292. We have got 108 saying no, and we have got 184 that has us saying yes. So now it means that the question is agreed to, and the Secretary will read the bill a first time.
Rates and monetary amounts and amendment of revenue laws a bill.
Thank you very much. We now, sorry for that. We now move to the, yes, I did. Yes, I said it was agreed to. We now move to the other one. Are there any objections to the Taxation Laws Amendment Bill being read a first time? Any objections? So,
House Chair,
yes.
the DA objects.
Thank you.
House Chair, please note the objection of the Freedom Front Plus.
That will be noted.
And that of the ACDP, thank you.
Thank you very much. That is also noted.
House Chairperson, may I clear something with you?
Yes.
And I'm perfectly open to the fact that I'm incorrect. But I was of the opinion that with the passing of this particular monetary bill, the House required a majority of 201
Yes.
voting yes.
Yeah.
And the House didn't get 201 voting yes.
Okay.
So we had over 201 votes cast, yes, but there weren't over 201 in favour. So can I just have an explanation as to where I misunderstood that particular junction, because I'm of the opinion that it doesn't pass.
Okay. No, on this particular one, I actually inquired before. It is 201 must be the majority of voters, whether negative or positive, and then the majority takes it. It's not the other one, what do you call the 2/3 majority thing. Thank you very much. So having got all those objections and noting them, the bill is being agreed to. And then now, I will ask the Secretary to read the bill a first time.
Taxation Laws Amendment Bill.
Thank you very much. We now say, are there any objections to the Tax Administration Laws Amendment Bill being read a second time?
House Chair, please note the objection of the DA.
The DA's objection is noted.
House Chairperson, please note the objection of the FF+.
Thank you, it's noted.
And that of the ACDP. And Chair, I appreciate your ruling on the majority, but I just want to make sure that it is in accordance with the rules, and I'm sure you have checked that. Are you satisfied? Thank you.
Thank you very much. I'm being advised, and I really asked that question even prior to this taking place, and that is the advice that I got. But if there's anything, you can continue to check on it. But I want to trust my table staff that they've given me the correct information. Honorable members, with all the objections, I now allow the Secretary to read the bill a second time.
Tax Administration Laws Amendment Bill.
Thank you very much. This bill will be sent to the National Council of Provinces for concurrence. Before I invite the Deputy Speaker, Ngiti Mina, thank you. Thank you. Egameni. Honorable members on the virtual platform, you don't have the right to do that. Come to the House and do that. Egameni liga somlomo we National Assembly, ngifuna ukufisela umhlonishwa umongameli ilanga elihle lokubelethwa. Sithi akhulele phezulu begodi abone eminye iminyaka eminingi. Begodu aragele phambili ngokusebenzela inaga yeSouth Africa kunene nagakazi yeAfrika uzimu amchudubaze. The Honorable, the Deputy Speaker.
Happy birthday to the President. Thank you, Honorable House Chairperson. The Secretary will read the 7th order.
Second reading, Rates and Monetary Amounts and Amendment of Revenue Laws Bill.
Are there any objections to the bill being read the second time? Honorable members, are there any objections to the bill being read the second time?
No.
No objections, agreed to. The Secretary will read the bill a second time.
Rates and Monetary Amounts and Amendment of Revenue Laws Bill.
Okay, the bill will be sent to the National Council of Provinces for concurrence. The Secretary will read the 8th order.
Second reading, Taxation Laws Amendment Bill.
Are there any objections to the bill being read the second time? No objections. Agreed to. The Secretary will read the bill a second time.
Taxation Laws Amendment Bill.
The bill will be sent to the National Council of Provinces for concurrence. The ninth order, the Secretary will read the ninth order.
Consideration of report of Portfolio Committee on Justice and Correctional Services on notice determining remuneration of Deputy Public Protector in terms of Section 2A of Public Protector Act 1995, Act number 23 of 1994.
And I call upon the Honorable G. Magwanishe to introduce the report. He's on the platform, on the virtual platform.
Thank you very much, Deputy Speaker and honorable members. I rise to present the report.
Honorable Magwanishe, can you shift your screen a little bit? We can't see your mouth. We also want to read your mouth. It's important. Ah, that's better. Thank you very much. Yeah. Thank you.
Thank you very much, Deputy Speaker and honorable members. I rise to present the report of the Portfolio Committee on Justice and Correctional Services on the notice determining the remuneration of the Deputy Public Protector in terms of Section 2, capital A of the Public Protector Act number 23 of 1994, dated 28 October 2020. On the 18th of August 2020, the President requested the National Assembly to consider the notice determining the remuneration payable to the Deputy Public Protector. Section 2, capital A of the Public Protector Act, read with Section 3 of the Determination of Remuneration of Office Bearers on Independent Constitutional Institution Laws Amendment Act of 2014, provides that the Deputy Public Protector is entitled to such salary, allowances, and benefits as determined by the President from time to time, by notice in the Gazette, after taking into account the recommendations of the Independent Commission and approved by the National Assembly. Section 2A and 5C of the Public Protector Act of 1994 requires the National Assembly to resolve either to approve the notice in whole or in part, or to disapprove the determination before it is published. The Independent Commission gazetted its recommendation on 13th February 2020 after consulting the institutions concerned and the relevant ministers. The President has not accepted the Independence Commission recommendation because of the following reasons. Firstly, the gap between the salary of the Public Protector, which is 2.3 million, and head deputy, which is 1.5 million, is considerable and is unique. No other Chapter 9 institution has such a significant gap between a head of an institution and their deputy. Secondly, the current salary of the Deputy Public Protector sees her earning significantly less than the executive management of the institution over which she shares oversight, thus undermining her authority to fulfill her responsibilities. Lastly, the salary earned by her predecessor was considerably higher than the salary she has been offered, and this difference was only communicated to her after she accepted the position and started her work. The President therefore proposes that the Deputy Public Protector's remuneration be set at 1.8 million per annum. The President also indicates that he has consulted the Ministers of Finance and the Minister of Justice and Correctional Services, and both were in agreement with the determination. Neither the President's letter nor the accompanying notice mentioned an effective date. However, the committee is of the view that the determination should take effect from the date on which the Deputy Public Protector, Advocate Koleka Gcaleka, took up office, namely 1st February 2020. Having considered the matter referred to it, the committee recommends that the National Assembly resolves to approve the notice determining the remuneration of the Deputy Public Protector in terms of Section 2A of the Public Protector Act. The committee recommends further that the effective date of the determination be the date on which Advocate Galega took up the office of Deputy Public Protector, namely the 1st February 2020. I recommend that the report be adopted. Thank you, Deputy Speaker.
Thank you. And now we'll recognize parties wishing to make a declaration. The ANC. Or shall we start with the DA? No, I'm sorry. We'll start with the DA. My apologies. The DA?
Thank you, Honourable Deputy Speaker. In a letter to the Speaker dated the 18th of August 2020, the President requested the National Assembly to consider the notice determining the salary, benefits and allowances payable to the Deputy Public Protector in terms of Section 2A of the Public Protector Act. The determination of the remuneration of office bearers on independent constitutional institutions laws and Amendment Act, which came into operation on the 1st of April 2019, creates the necessary framework to determine the salaries of office bearers of the Chapter 9 institutions. Among others, the Act amends the Public Protector Act to provide a process for determining the salary of the Public Protector and the Deputy Public Protector. The Independent Commission gazetted its recommendations on the 13th of February 2020 in Government Gazette number 43019 on the 13th of February 2020, having consulted with the institutions concerned and the relevant ministers to better understand the remuneration of office bearers in the various independent constitutional institutions, as well as related concerns and challenges. The Commission, among others, recommended that the salary of the Deputy Public Protector be adjusted from 1.446 million to 1.504 million. In his letter dated the 18th of August 2020, the President proposes that the Deputy Public Protector's remuneration be set at 1.814 million per annum. And he sets out the reasons for not accepting the recommendations of the Independent Commission. He mentions firstly the gap between the salary of the Public Protector and her deputy is considerable and is unique. Secondly, that the Deputy Public Protector sees her earning significantly less than the executive management of the institution over which she shares oversight and undermines her authority. And then he refers to the salary of her predecessor. The current Deputy Public Protector applied for the job and was appointed pursuant to an extensive public interview process, apparently without determining the salary scale at which she was to be appointed. The Deputy Public Protector now says that she asked Advocate Malunga, the previous incumbent, what he earned, and then just assumed that that would be her salary, and that she was now therefore unhappy with the salary that she was earning. It must be borne in mind that the salary that Advocate Malunga was earning was at the end of a 2-term tenure, and not the salary that he earned at the outset of employment in that office. South Africa is in a fiscal crisis, honourable members. The public wage bill needs to be carefully managed and trimmed where possible. Thousands of South Africans have lost their jobs, and there's simply no justification, in our view, for the increased starting salary of the Deputy Public Protector at this point. Any responsible applicant would have found out all the relevant details of the position, including the remuneration, before applying for and eventually accepting the position. Complaining after the fact is not acceptable, and accommodating those complaints is even less so in the current circumstances. Our economy simply cannot afford to be held to ransom in this fashion. The argument that the authority of the Deputy Public Protector is undermined by the fact that she earns less than some of her juniors is laughable in the face of the current litigation being conducted in the Supreme Court of Appeal by the National Prosecuting Authority and the Department of Justice against their own Deputy Directors of Public Prosecutions, who were found recently by the High Court to have been severely prejudiced by the non-implementation of the occupation-specific dispensation, and who all earn less than the senior state advocates whom they supervise and lead in court daily, and in which the state seeks a cost order against its own employees. But for these reasons, Honourable Deputy Speaker, the Democratic Alliance does not support this report. I thank you.
Thank you. EFF.
Thank you very much, Deputy Speaker.
Chairperson, Deputy Speaker, the Office of the Public Protector is one of the most important cogs for holding our democracy intact and for giving citizens recourse against abuse and maladministration by those elected. It affords citizens the right to challenge government's excesses, as it rightfully did when President Zuma thought he could use public funds for private benefit. And as it rightfully investigated the use for private wealth to prop up puppet presidents, when it showed that the current president owed his position to the whites who pumped billions into his campaign.
Deputy Speaker, on a point of order. Deputy Speaker.
Yes. Yes, Honourable Member.
Deputy Speaker, I rise on a point of order. Deputy Speaker, there is a rule in the House that
Yes.
no party symbols may be shown during a sitting of the House. And the honourable member from the EFF currently on the podium is wearing an EFF beret in her photo. And I would ask that that photo be removed, please.
Honourable members, you understand the rules. Please, let's comply.
Can IT then just remove my picture from everything, because I can't remove it from where I am?
Okay, all right. Go ahead, Honourable Member.
Yeah, is it possible?
But they will indicate if they will be able to do that.
I'm sure they can.
Honourable Speaker,
Yeah, go ahead.
she must remove the
Yes, Honourable Member.
She must just switch off the video.
The video is off, ma'am, but the picture is there. So what must I do now?
Switch on your own video.
I cannot
Honourable
switch on my
members.
video as I'm not dressed properly for the meeting
Faka
right now.
amapijama yini? Hayibo.
Order, Honourable Chief Whip, order.
No, but she knows that IT can remove that picture.
Go ahead,
if they
Honourable
want.
Member.
Thank you. No, ndiyazazi mama Mandipangele, but at the same time, I need to respect my party. Can we carry on?
Honourable Member, talk to me. Honourable members, stop engaging the member. We have made a
Thank you
ruling on
very
this
much.
thing. Its effect will be that. It will not be allowed next time.
Thank you.
Absolutely. There is no
Thank
room
you.
for compromise
Thank
on
you.
this matter of
You must
dress code
forfeit their right to
and
speak.
symbols.
Thank you,
Go
Chair.
ahead. No,
Because of this
you
very-
don't have
Speaker,
any
on a point of
authority
order,
to
Speaker.
suggest that.
On a point
Go
of
ahead,
order,
Honourable
Speaker.
Member.
Deputy Speaker,
Yes, what's happening now, Honourable Member?
I'm actually worried that this will set precedents. The member is not supposed to
No, Honourable Members. Honourable Members, you can't contest a ruling I've made. If you have an objection, you know what to do. You write to the Speaker and you complain about the ruling that I have made. You
What
can't
is your
contest
ruling,
a ruling.
Speaker? What is the
You know, you should know the rules, Honourable
No,
Members.
what is the ruling?
Very much, Deputy Speaker. You have made
The
your
ruling is that the
Thank
Honourable
you.
Member will proceed.
Proceed
And I
with
rule
what?
that dress code is inappropriate. Honourable Chief Whip, no, you can't be doing what you are doing.
No, I'm asking
Please.
because we don't hear you.
Please,
Just throw her out of the House, Deputy Speaker, because she don't want to hear.
Honourable members, please don't tell me what to do. You allow the member to proceed to speak. You have no business to be interfering with the proceedings in the manner in which you are doing.
Mistake is not accepted. That mistake is not acceptable.
Thank you, Speaker. Thank you, Deputy Speaker. May I carry on?
You are being contemptuous, if I may suggest to you. You are being contemptuous.
Apologies, Honourable
And you know the
Speaker.
rules. The rules say that you shouldn't contest the rulings of a presiding officer. So why do you think you can do it and get away with it? On what authority do you base that decision? No, you can't do that. You shouldn't do that.
But we did not hear what your ruling is, Deputy Speaker. We request that you repeat this ruling.
I repeated it twice, Honourable Chief Whip. I repeated it twice.
Can you repeat
I
it for the
repeated
third
my
time?
ruling twice. And I'm still saying that she must proceed. We have ruled on the matter that such symbols are inappropriate on the staff and that they shouldn't be allowed. And so I'm not going to get engaged in whether it is doable now or not.
Oh,
She's going to
no.
go ahead now. Please go ahead, Honourable Member.
But that is out of order, Deputy Speaker.
Go ahead, Honourable Member.
Thank you very much, Speaker, Deputy Speaker. Because of this very important role of this office plays, The leaders of that institution ought to be remunerated fairly, and their security needs to be guaranteed. We agree with the logic used by Mr. Ramaphosa in deciding that to rationalize the Deputy Public Protector's salary to 1.8 million per annum. The salary she was offered before was, as the report notes, even lower than that of the people who are supposed to be subordinate to her. What is even more shocking is that her salary was lower than the salary earned by the previous Deputy Public Protector, Kevin Malunga. So a woman doing work of equal value was offered a salary far less than her male predecessor. This should be shocking to all of us into shame. We welcome this report and offer our support fully to the Deputy Public Protector. We further urge her to resist all temptation that will surely come for her to distance herself from her boss, Advocate Bosisiwe Mkhobane. The strength of the Office of the Public Protector lies in the unity of the leadership and the recognition by the leadership that there is only one enemy they have to fight, and that enemy are those who keep misusing their authority to serve themselves rather than the public. The Office of the Public Protector therefore needs all the resources and all the support society can muster to ensure that they remain insulated from dominant political influences and do their jobs without fear or favor. So therefore, the EFF supports this report. Thank you very much, Deputy Speaker.
Thank you. FF Plus?
IFP Speaker, first.
Oh, IFP, you're right, yeah. Go ahead, Honorable Singh.
It will be Honorable MC Monk.
Please unmute Honorable Msimang. Honorable Msimang. Prof, we are not hearing you. Just unmute your button there.
Deputy Speaker, may I proceed?
I thought you guys had dealt with this matter.
The IFP agrees with the Portfolio Committee on Justice and Correctional Services recommendation that the National Assembly resolve to approve the notice determining the remuneration of the Deputy Public Protector in terms of Section 2A of the Public Protector Act. The IFP furthermore agrees with the Portfolio Committee's recommendation that the effective date of the determination reflects the date on which Advocate Kalega took up the office of Deputy Public Protector. The IFP, The IFP has taken consideration of reasons provided by the President for his determination concerning the remuneration payable to the Deputy Public Protector, and that the President has consulted both the Minister of Finance and Justice and Correctional Services on the matter. Thank you, Honorable Deputy Speaker.
Thank you. FF Plus.
Honourable Deputy Speaker, the FF Plus is not going to make a declaration. Thank you.
Okay. ACDP.
Thank you, Deputy Speaker. Deputy Speaker, this is a very interesting determination, and up to now, most of the determinations where the Independent Commission has made recommendations have not been followed by the President due to fiscal constraints. And in fact, there's been a lowering and a salary freeze on those that have been earning more than 1.5 million. But in this case, the President has elected to increase the determination and not follow the Independent Commission's recommendation. And so I appreciate the concerns that have been expressed on an issue of consistency and on the issue of the fiscal constraints facing the nation. However, when one considers the reasons that have been given, they are compelling. The President, and may we also congratulate him on his birthday today, on his 68th birthday, he indicates that the gap between the salary of the Public Protector and her deputy is considerable and is unique, and that no other Chapter 9 institution has such a significant gap between the head of an institution and their deputy. Now, this is 800,000 Rand gap. Secondly, the President indicates that the current salary of the Deputy Public Protector sees her earning significantly less than the executive management of the institution over which she shares oversight, thus undermining her authority to fulfill her responsibilities. The argument is made that this is happening in other institutions such as the MPA, but that is intolerable in the MPA and also needs to be addressed there, I would say. Lastly, the salary earned by her predecessor, Advocate Kevin Malunga, was considerably higher than the salary she's been offered, and this difference was only communicated to her after she accepted the position and started her work. Now, we from the ACDP's perspective clearly believe that women doing the work of equal value should be paid equal salaries, and the present situation without this presidential determination is intolerable and should be rectified by this salary determination. The question arises why the Commission made this erroneous determination in the first place, and this was discussed during the Portfolio Committee. The President has indicated that he has discussed and consulted the Ministers of Finance, Justice and Correctional Services, as well as the matter being dealt with by the Portfolio Committee, and given these reasons, whilst balancing against what has been said with the fiscal constraints, the ACDP believes that we should support this report. I thank you.
The UDM. ATM. Good. NFP.
Thank you, Deputy Speaker. The National Freedom Party notes the report of the Portfolio Committee on Justice and Correctional Services on notice determining the remuneration of Deputy Public Protector in terms of Section 2A of Public Protector Act 1994, Act number 23 of 1994. In his letter dated 18th of August 2020, the President proposed that the Deputy Public Protector's remuneration be set at 1,814,065 rand per annum. The President explained his reasons, which were sound and reasonable. However, the conundrum we're sitting with is a wage bill of 629.2 billion, mounting up exponentially despite the efforts made to cut, freeze, and reduce the wage bill. Ms. Kholeka was previously paid, Honorable Deputy Speaker, 300,000 rand per year, less than her predecessor. And I'm not sure if this reason is because she's a female. Her predecessor has been a male that's been earning more. But if that is the case, then it's totally unacceptable, although there's no evidence in that direction. The National Freedom Party acknowledges and welcomes the proposed remuneration of the Deputy Public Protector for reasons outlined above. Most importantly, that the Deputy Public Protector cannot be earning far less than the executive overseas. The National Freedom Party notes, considers, and supports this. Thank you very much.
Thank you. AIC. Cope.
Thank you, Deputy Speaker. COPE supports the proposal put before this House. Our support is based on the expected work the Deputy Public Protector must execute for the people of South Africa. COPE checked her qualifications, experience she has acquired, work done by the Portfolio Committee, and the reality that the difference between the salaries of the Public Protector and the Deputy is too much. The Public Protector's office, and I emphasize office, consists of two people. Just like the presidency, you talk about two people. And therefore, the salaries cannot just be like it is with the office of the Public Protector. As a country, we are faced with serious historical problems. Inter alia, problems of corruption, killings of South Africans, and other West kind of problems. Now, as a sequel to corruption and theft and killings, we have commissions, including the Zondo Commission. We still have got to have the Public Protector and the Deputy doing all the work. And therefore, we do agree with the proposal. Thank you.
Thank you. PAC. Al Jama.
Thank you very much, Honorable Deputy Speaker. Honorable Deputy Speaker, we need to enhance the status of the Deputy Public Protector because it's very important for us to have the speedy resolution service available. Like in the early days, Deputy Speaker, we had labor problems that was very, very expensive. And that's why the CCMA was created. Here we know that the public protector and the support, like the deputy and so on, plays a very important role to provide people with a service that doesn't require legal expenses and denies them the right to put issues. So I'd like to congratulate the Portfolio Committee for supporting the recommendations made and in the end for recommending that this proposal be accepted. We support the proposal, Honourable Deputy Speaker.
Thank you. ANC.
Thank you, Deputy Speaker. The African National Congress rises in support of the report of the Portfolio Committee on Justice and Correctional Services on the notice of the remuneration of the Deputy Public Protector in terms of Section 2A of the Public Protector Act. In October this year, the country celebrated 25 years of the establishment of the Office of the Public Protector. Once again, we convey our appreciation to this critical institution, which was established to support our relatively young democracy. The existence of the Office of the Public Protector reaffirms the call of 1955, which was made in Kliptown, that the people shall govern. Over the past 25 years, the Office of the Public Protector has been instrumental in transferring power to the people and in encouraging people to speak out against maladministration with the surety that their complaints will be taken seriously. It has been instrumental in promoting a transparent and accountable government that is answerable to the people. In the 2019-2020 performance report, the office reported that it managed to achieve 79% of their targets, improving from 72% from the previous year. This has been steady climb when judging by the performance in 2017-2018, which stood at 50%. In a letter to the Speaker dated the 18th August 2020, the President requested the National Assembly to consider the notice determining the salary, benefit and allowances payable to the Deputy Public Protector in terms of Section 2A of the Public Protector A. The Independent Commission gazetted in its recommendation on the 13th of February 2020, among others, recommending that the salary of the Deputy Public Protector be adjusted from 1,446,368 rands to 1,504,233 rands per annum. In his letter, the President rejected the Commission's proposal and proposed that Deputy Public Protector's remuneration be set at 1,814,065 rands, which is at the same level as the incumbent's predecessor. The President considered a number of factors which include the considerable and unique gap between the salary of the Public Protector and that of the Deputy Public Protector, and that no other Chapter 9 institution had such a significant gap between a head of an institution and their deputy. That the current salary of the Deputy Public Protector is earning significantly less than the executive management of the institute over which she shares oversight. That the salary earned by the predecessor was considerably high than the salary she was offered. The President further indicated that he had consulted the Ministers of Finance and Justice and Correctional Services, and both were in agreement with the determination. Deputy Speaker, The doctrine of legitimate expectation entails that a reasonable expectation based on a well-established practice or an express promise by an administrator acting lawfully gives rise to legal protection when the practice or promise is clear. When the salary of the Deputy Public Protector was not included in the advertisement, an expectation that a candidate interested in the position of Deputy Public Protector will earn the same salary, same or similar salary as the predecessor is legitimate, reasonable, and justifiable. In addition, rejecting the proposal made by the President in this regard would send a dangerous message to the society. That message would be a contradiction to what we stand for, the total emancipation of women. To this end, I wish to quote Felicity Jones, who said, close open quote, "I want to be paid fairly to the work that I'm doing. That's what every single woman around the world wants. We want to be paid on parity with the men in a similar position," close quote. In conclusion, the independent commission should consider looking at the issue of remuneration and benefits of the various Chapter 9 institutions, uniformity, and ultimately fairness. Thank you, ANC supports.
Deputy Speaker, unmute yourself.
Sorry. Are there any objections to the adoption of the report of the Portfolio Committee on Justice and Correctional Services, which recommends, amongst other things, the approval of the notice determining remuneration of the Deputy Public Protector? Any objections?
Deputy Speaker, please note the objection of the Democratic Alliance.
Will do.
Thank you, Chairperson. As Speaker, as well as the objection.
Freedom Front Plus?
Yes, thank you.
Okay, will do. Okay, with those objections noted, the recommendation is agreed to. Before I proceed to the 10th order, there are two outstanding rulings that I would like to make. The third one will be made by Honorable Buroto before we close proceedings today. Honorable members, on Tuesday, August, during the debate on Black Lives Matter, reinforcing the commitment of all South Africans to confront and defeat individual and institutional racism in our society and everywhere else it exists, Honorable C.P. Mulder rose on a point of order in response to the following remarks allegedly made by Honorable P.N. Abram. Honorable Mulder of Freedom Front Plus, your time to dish out racist tendencies using Christianity is over. Dr. Mulder then rose on a point of order and said, and I quote, "I didn't participate in the debate, first of all, and secondly, the honorable member, she refers to me and my racist tendencies. I think that's unparliamentary and she should withdraw. Thank you." I then proceeded to ask the Honorable Abram if she had altered the alleged remarks, to which she replied, "No, Deputy Speaker." This is her words. I undertook to study Hansard and returned to the House with a ruling on the matter. Having listened to the Hansard audio recording, I would like to confirm that indeed Ms. Abrams made those utterances. Accordingly, I rule as follows, that Rule 84 and the rules governing offensive and parliamentary language are broadly framed in order to allow honorable members to enjoy their constitutional right to freedom of speech. However, well-established practice also dictates that any statement or remark which impairs the dignity of the person to whom it is directed or affronts that person's honor, such statements cannot enjoy the privilege of freedom of speech accorded in the usual course of parliamentary proceedings. The debate on Black Lives Matter and the commitment to eradicate racism was an important debate for members to participate in the fight against racism. In view of our history, it is incumbent on members to actively take the lead to rid our society of its racist heritage. I would also emphasize that when members participate in such debates in the House, members has a unique opportunity to actively inculcate and promote the values of tolerance, diversity, inclusivity, and they should be setting standards in that regard. Members should also be sensitive to the messages they convey in their exchanges. It is always unparliamentary and out of order to accuse another member of racist tendencies. It was wrong and unparliamentary for Honorable Abraham to accuse Honorable Melda of racist tendencies. I therefore have to ask the Honorable Abraham to withdraw her remarks. Honorable Abraham, please rise, or if you're on the platform, indicate your presence and do as I request. Is the Honorable Member present?
Deputy Speaker, is
yes, Honorable Buroto.
Which Honorable Abraham? PN.
Yes.
Okay.
Is she here? If she's not here, Honorable Buroto.
Yes, Deputy Speaker. Unfortunately, they have not, I don't think she's logged in according to the table staff.
In her absence, Honorable Buroto, I will proceed to complete the ruling because in addition to the ruling I have just made, it is also further that having given an opportunity to confirm whether indeed she uttered the words, Ms. Abraham went on record again and denied the allegation, thereby, in effect, deliberately misleading the chairperson, in other words, the presiding officer and the House. In this regard, I must point out that Section 17 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act state that a member is guilty of contempt if he or she willfully furnishes a House or committees with information or makes a statement before it which is false or misleading. In light of this, I have no option but to refer the matter to the Speaker to consider whether Ms. Abraham's conduct requires further action in terms of the Act as indicated. When the member is back in the House at any time, I will discuss this with the rest of the presiding officers so that the honorable member does as is expected of her to withdraw, and the rest will proceed as I have ruled. The second ruling that I would like to make is that on July 8th, during consideration of the revised fiscal framework, the minister in the presidency, Honorable Jackson Tembu, rose on a point of order contending that Mr. N.F. Chivambo of the EFF had referred to the President of the Republic as a puppet president who is a puppet of the white monopoly establishment. Mr. Tembu contended that this constituted unparliamentary language and had to be withdrawn. At the time, I undertook to follow up and came back to the House with a ruling. From the recorded sound clip provided by Hansard, Mr. Chivambo can be clearly heard saying it. Honorable members, Rule 84 clearly states that no member may use offensive, abusive, insulting, disrespectful, unbecoming, unparliamentary words or language, nor offensive, unbecoming, or threatening gestures. Further, there have been numerous rulings over the years that members may not impute improper motives to other members or cast personal reflection on their integrity or dignity. This has since been clearly codified in Rule 85. Mr. Shivambo's remarks suggest that the president is beholden to someone or something behind the scenes that controls him as president, and implies that he is acting in ways other than the dictates of his oath of office. This casts personal reflections upon the integrity and dignity of the president. It is also apparent from the manner in which the remarks were made that they were not only intended to imply some improper, unethical conduct on the part of the president, but were aimed at insulting and offending the president as a person. Our freedom of speech as members is unfettered, subject only to the Constitution and the very rules of the Assembly, to which we at all have taken an oath to abide by. Mr. Shivambo's remarks are clearly in breach of these rules. The conventions of the past rulings of this Parliament must be, those remarks must be withdrawn. Honorable Shivambo, we require you to withdraw those remarks. Is Honorable Shivambo present? Honorable Shivambo?
Honorable Shivambo is not in the House, Chair.
Okay. This ruling stands, and Honorable Shivambo will be expected to withdraw when he is back in the House. Thank you, honorable members. We will now proceed to the 10th order. The Secretary will read the last order of the day.
Consideration of request for approval by Parliament of agreement between the Government of the Republic of South Africa and the European Atomic Energy Community for cooperation in the peaceful uses of energy in terms of Section 2312 of the Constitution.
I now call upon Honorable Luzipo to introduce the report. Go ahead, Honorable Chairperson.
Thank you, Honorable Speaker, honorable members. Maybe you are going to be promoted, we may never know. The Euratom Agreement was signed between the Government of the Republic of South Africa and the European Atomic Energy Community for cooperation in the peaceful uses of energy, of nuclear energy, which was supposed to have commenced by 2013. This is an important agreement and part of our bilateral and multilateral responsibilities as a country with a nuclear capacity for peaceful uses, amongst those specifically being energy production and nuclear medicine. This agreement is a cooperative agreement between South Africa and the European Atomic Energy Community. The agreement is premised on a nuclear non-proliferation and all the rules and regulations of the International Atomic Agency, of which both South Africa and the Euratom are important members. The agreement allows the joint research between Euratom and South Africa to enhance scientific cooperation, which allows the countries to remain at the helm of developments in the nuclear industry. It allows for research organization in the nuclear sector to participate in each other's research project, both in South Africa and within the European Union, which will be mutually
beneficiary for both parties. This is an agreement that does not remove the independence of research organization in South Africa or in the European Union. It encompasses cooperation in the nuclear sphere in relation to nuclear medicine and also as an application to agriculture. It commits both parties to the agreement to ensure nuclear safety and proper waste management, given the radioactive nature of the technology, which requires, by definition, such high standard of safety as is the case in South Africa and in the European Union. It is based on the peaceful uses of nuclear energy and correctly does not allow for any research or material produced to be utilized by either party for the development of or research of or on weapons. The use of nuclear energy for peaceful means reflects the policy of our government. The agreement regulates the movement of nuclear material and technology between EU members of the Euratom and South Africa. This ensures that transfer of nuclear material and technology occurs in a safe and regulated manner for the peaceful use of nuclear energy. Exchange of information and intellectual property is safeguarded for both parties to the agreement in accordance with the international norms, standards, and law. The agreement does not seek to create any competitive advantage for either party, as it is a cooperative agreement. Therefore, no commercial advantage or disadvantage will accrue to any party which is a signatory to the agreement. The agreement recognizes the laws of South Africa, of the Republic of South Africa, and that of the European Union as governed by their laws. International legislation, regulation, and international nuclear agreements guide the conduct of the parties to the agreement. Member states of the European Union, through this agreement, are also allowed to enter individual agreements with South Africa, and therefore this agreement does not restrict the country's development in the nuclear field and any other country. The agreement has a technology management plan which does not infringe on the rights of any party to the agreement, as the transfer of technology for nuclear energy is governed by international covenants to which South Africa strongly adheres. The Portfolio Committee, therefore, having considered the agreement between the Republic of South Africa and the European Atomic Energy Community, which is Euratom, for cooperation in the peaceful uses of nuclear energy, and the accompanying explanatory memorandum, recommends that the House approve the agreement in terms of Section 231, subsection 2 of the Constitution of the Republic. We recommend for the adoption of the agreement. Thank you, Honourable Speaker.
Deputy Speaker.
The DA.
Thank you, Deputy Speaker. When we hear the word nuclear, it triggers images of mushroom clouds.
On a point of order.
Yes, Honourable Member.
With the previous ruling that we have just made.
Yes, Honourable Member.
Yes.
Honourable Chief Whip.
Yes, Honourable Speaker, Deputy Speaker, thank you very much. I'm rising on a point of order. The member on the podium is having a DA logo on the mask.
Okay, honourable members, you know you are not supposed to put on masks, and that's or rather you are not supposed to put on logos on yourself, so it's out of order. So,
Deputy
honourable member,
Speaker,
you will remove that logo, you will find an appropriate mask
Deputy
without
Speaker,
the logo.
Deputy Speaker,
and you know the rules.
Deputy Speaker, I apologize profusely. I apologize profusely. I thought you'd set a precedent with your previous ruling that in this session we could wear regalia, but I'll take it off. It's fine.
There is no precedent set. A member was online on technology, and that thing, if it could not be done, could not be done. your manual can operate and you remove it. That's correct that you have moved it. But the first thing you must do as soon as you leave that platform, you found a mask. And that's a rule and an expectation as well. This is deliberate defiance of the rule. Two wrongs don't make a right.
It's off, Chair, Deputy Speaker. Can I continue?
Go ahead, go ahead.
Deputy Speaker, when we hear the word nuclear, it triggers images of mushroom clouds, nuclear plant failures like Chernobyl and Fukushima, and strange mutations. But what's not mentioned in these many discussions are the many tangible and safe benefits that we experience on a daily basis from the scientific development of nuclear technology. We have X-rays, MRIs, and CT scans at the hospital or at the dentist without thinking about it. We use radiation treatment for cancer. Every time we use a microwave oven, we are harnessing the power of the atom to radiate and cook our food. Since the dawn of the nuclear age in the mid-1940s, nuclear technology has powered the development of many facets of medicine, industry, and indeed our very understanding of the universe. Nuclear power plants provide reliable electricity in more than 30 countries, thanks in part to the Nuclear Non-Proliferation Treaty, which set a framework for increasing access to peaceful use of nuclear technology. In South Africa, we have long been at the forefront of the adoption of nuclear technology and scientific research. We are considered world leaders in the production of radioactive isotopes, in some instances providing up to a third of the world's supply. It is a little-known fact that it was a South African-born physicist, Alan MacLeod Cormack, whose research in X-ray technology led him to developing the theoretical underpinnings of CT scanning and ultimately winning the 1979 Nobel Prize in Physiology and Medicine for his pioneering work in this field. And yet, South Africans generally exhibit particularly low levels of knowledge about nuclear energy and technology. A Human Sciences Research Council study in 2012 found that only a very few claimed to be knowledgeable or somewhat knowledgeable, with greater numbers reporting that they were not very or not at all knowledgeable about nuclear energy. Almost a third of all respondents were unable to express an opinion, instead opting to provide a do not know response. So clearly, there is an important need to educate South Africans on the risks, but also the benefits and implications of nuclear technology across a range of fields, not just electricity generation. Nuclear safety is a global issue. And this was tragically demonstrated by the Chernobyl accident, which brought home to everyone that an accident anywhere is an accident everywhere. And this is where associations with organizations such as Euratom come in. The European Atomic Energy Community, Euratom, is a European organization established under the Treaty of Rome in 1957 to coordinate the research programs of the EU member states for the peaceful use of nuclear technology. The EU has its own joint research center in the nuclear field, and this joint research center has become an institution of prime importance for nuclear research in Europe. Their research activities cover the following areas: energy from nuclear fusion, with the aim of developing a technology exploiting nuclear fusion as a safe, sustainable, and environmentally friendly energy source; nuclear fission and radiation protection, to promote the safe use of nuclear fission to produce energy and other applications in industry and medicine; nuclear safeguards and standards, including appropriate emergency preparedness and response; and the management of radioactive waste and spent fuel, as well as the safe and responsible decommissioning of nuclear facilities. The program is implemented through contracts of association between Euratom and member states or associated countries or research organizations, and it is this which we seek to approve today. This agreement will permit multi-level interactions between South African entities, government departments, nuclear practitioners, and experts with their counterparts in EU countries who may have specific expertise that can contribute to the development of South Africa's nuclear industry. Deputy Speaker, this agreement has been delayed for far too long. The Democratic Alliance supports the adoption of this report. Thank you.
EFF. EFF. IFP.
Thank you very much, Deputy Speaker. Please allow me not to switch on my camera. Deputy Speaker, on the outset, the IFP supports the agreement between the Republic of South Africa and the European Atomic Energy, Euratom, for the cooperation in the peaceful uses of nuclear energy, including the accompanying exploratory memorandum, Honourable Speaker, which has been tabled in terms of Section 231, subsection 2 of our Constitution, and the recommendation that the House approve the agreement. Honourable Deputy Speaker, nuclear energy will continue to play a pivotal role in South Africa's energy mix for the foreseeable future. It is therefore not only necessary, but also borne out of the duty for the responsible and safe use of this nuclear energy that such agreements are entered into with our international partners. International practices and cooperation for mutual benefit, which includes nuclear research and development, nuclear safeguard, and the transfer of nuclear equipment and materials, is essential if we are to utilize this energy source for the maximum benefit of the people of our country. Whilst this country's energy mix still largely is dominated by coal, this will gradually reduce with the nuclear energy increasing. It is therefore of paramount importance, Honourable Speaker, that we, Deputy Speaker, that we ensure that our usage of nuclear energy complies with the highest safety standard and international best practices. Thank you.
Thank you. FF Plus.
Deputy Speaker, Parliament is today requested to ratify the agreement between South Africa and the European Atomic Energy Community for cooperation in peaceful uses of nuclear energy. Om 'n party tot hierdie ooreenkoms te wees, is 'n erkenning vir Suid-Afrika se noemenswaardige kundigheid en tegniese vermoë op die gebied van kernenergie. Van die vorige bedeling het die ANC-regering 'n sterk ontwikkelde kernenergie nywerheid geërf. Na bewering het daardie regering ook 6 kernbomme in wisselende stadia van voltooiing gehad, maar dit is afgetakel en nooit gebruik. Vandag is vriend en vyand bly dat oud-president Zuma en niemand anders in die ANC sal gespeelgoed gehad het. Maar die vreedsame gebruike wat oor was, bly indrukwekkend. Die Koeberg kragsentrale het 'n wesenlike rol gespeel om die luggies in Suid-Afrika aan te. Die radioisotope vir mediese gebruike en fluorochemiese produkte van 'n nywerheidstoepassing wat by Pelindaba vervaardig word, is steeds van die beste op die aarde. Selfs belangriker as prestige, dit verdien goeie geld. Kernafval, daardie nuwe produkte wat vir eeuwig gevaarlik bly, word ook verantwoordelik op die grens geberg. By valputs op die grens in Namakwaland en Bushmanland in die Noord-Kaap. Maar helaas, die vernietiging van maladministrasie is kragtiger as die van 'n atoombom, al gaan dit stadiger. NECSA, die Nuclear Energy Corporation of South Africa, wat vir hierdie werk verantwoordelik is, ly ernstig onder maladministrasie. In Desember 2018 is die voorsitter en grootste deel van die NECSA raad, sowel as die hoofuitvoerende beampte, deur die destydse minister van Energie, meneer Jeff Gadebe, afgedank. Intussen sukkel NECSA om sy lisensiegelde te betaal en banke sowel as een van sy eie filiale moet noodgedwonge krediet aan NECSA verleen. As gevolg van COVID-19 verklaar die huidige raadsvoorsitter dat die verwagte kleinwins na 'n verlies van 331 miljoen rand gedaal het. Die Grendelstaat, nog 'n atoombom wat die ANC gebou het. In Julie 2018 stuur Maroos Karnaro 'n vriendelike dog effens ongeduldige briefie aan meneer Gadebe om te herinner dat die EU reeds sy deel gedoen het en net op die RSA wag om die ooreenkoms te bekragtig. En hier geen 28 maande later nie, dien dit reeds voor die parlement. En dalk is dit hoekom mense huiwerig is oor kernkrag. Jou planne kan so goed as moontlik wees, maar die afval bly eeuwenlang gevaarlik en hoe weet jy wie regeer na jou die land? Daarom is dit goed om internasionale medewerking en selfs toesig te betrek. Die VF+ ondersteun daarom die bekragtiging van hierdie ooreenkoms. Dankie, adjunkt spreker. Ek is klaar, adjunkt spreker. Baie dankie.
ACDP.
Thank you, Deputy Speaker. It is the view of the African Christian Democratic Party that when considering the agreement between the Republic of South Africa and the European Atomic Energy Community for cooperation in the peaceful uses of nuclear energy, the operative words are peaceful uses. Clearly, our energy mix, nuclear energy, currently plays an important role in meeting the energy needs of South Africa. Understandably, there are many who have grave concerns about the use of nuclear energy, given its history and political abuses by certain countries. One only has to think of the devastation and pain inflicted on those in Hiroshima and Nagasaki during the Second World War, the Chernobyl disaster in the Ukraine in 1986, and the threats by countries like Iran and North Korea to use their nuclear capability for political gain. Our nuclear democracy, or rather our new democracy, has inherited the 2 reactors in Koeberg nuclear power station, positioning South Africa as the only country in Africa with a commercial nuclear power plant. It is imperative that we utilize the inherited Koeberg nuclear power station with diligence and care. The main purpose of the cooperation agreement as presented to the committee is to expand and deepen the mutual beneficial economic, scientific, and technical cooperation. This may include research and development in the field of nuclear, use of nuclear materials and technologies such as the applications in health and agriculture, the transfer of nuclear materials and equipment, nuclear safeguards, nuclear safety and radioactive waste and spent fuel management, decommissioning and radiation protection, including emergency preparedness and response. Deputy Speaker, the ACDP understands that there are certainly some countries that have a more advanced institutional knowledge as well as skill sets with regards to research and development capabilities than South Africa has in terms of nuclear advancement and safe disposal of nuclear waste. And so in supporting this agreement, the ACDP encourages that we take advantage of the cooperative agreement and that the safety of South Africans are prioritized, and that our country and indeed Africa as a whole does not become the dumping ground of European or first world nuclear waste, of European or first world nuclear energy waste. I thank you.
Thank you. UDM? ATM? Good. NFP?
Thank you, Deputy Speaker. Deputy Speaker, the National Freedom Party notes the consideration of request for approval of agreement between the Government of the Republic of South Africa and the European Atomic Energy Community. But let me just start off by saying, Honourable Deputy Speaker, agreements of this nature should be and must be concluded with all countries throughout the globe. It should not be with selected countries, because then it means some countries have an edge over other countries. One ideal example I want to give in response to what I've just heard my colleague say, exactly what happened in Iraq. The United States has said that Syria, Iraq have all had nuclear weapons. Did they find anything there? Absolutely nothing. It is because certain superpowers, particularly in this world, want control and power over the smaller countries, and that is the problem, particularly for their resources. And we must be mindful of that. The agreement was signed in 2013 and was subsequently approved by Cabinet in 2018. The main purpose of the cooperation agreement is to further expand and deepen the mutual beneficial economic, scientific, and technical cooperation, which include, among others, research and development in the field of nuclear transfer of nuclear materials and equipment, nuclear safeguards, and the use of nuclear materials and technologies such as applications in health and agriculture. And the National Freedom Party welcomes this agreement that we are entering into. If either party or member state of the committee violates any of the material provisions of the agreement, the other party may, on given written notice to that effect, suspend or terminate in whole or in part cooperation under the agreement. So I think there are checks and balances in place. Termination of this agreement shall not affect the implementation of any arrangements and or contracts made during the period of its validity, but still not completed by the date of its termination unless otherwise agreed upon by the parties. The National Freedom Party welcomes the recommendation of the Portfolio Committee and supports this. Thank you very much.
AIC? Hope.
Ke a leboga ba bagolo le ka feta Thobela.
Honorable Madisha requests that you proceed to the next party.
Oh, okay. Sorry, I missed hearing him there. PAC? Al Jama?
Thank you, Honorable Deputy Speaker. Honorable Deputy Speaker, I'm sure you'll be the first person that will agree with me that an agreement between one African country and the European Union cannot be stronger than an agreement between all the African countries and the European Union. But that's just an opinion that you will feel that way. It is very important that going forward, that we do not forget the other countries in Africa. And this would have been an ideal opportunity to reach an agreement between the countries in Africa and the European Union, so that the advancement of technology will be of benefit to all the African countries. Having said that, we must also be amenable to the fact that there are other countries outside the European Union that South Africa can learn a lot from to get the benefit that the official opposition so clearly spelled out to the House. And I'm thinking of Pakistan, I'm thinking of India, I'm thinking of North Korea. So those may be Asian countries. But, we like to label countries Asian, European, African, but there's also Iran. And they have technology, they have safety precautions built in when there's a disaster. Why can't Africa also benefit from it? So while we would have preferred a continental agreement with the European Union, and it would have been the easiest thing to get African countries to agree to it. The other issues are very complicated. We feel that the agreement with the European Union is a step in the right direction, but South Africa must widen its horizons, Honorable Deputy Speaker. Thank you very much.
Thank you very much. ANC?
Honorable Chair, it was first the EFF, please, Chair, before the ANC.
What happened to you? Yeah, okay, go ahead.
Chairperson.
Sorry, Honorable Member. Go ahead, Honorable Member, the EFF.
Thank you, Chair. Thank you, Chair. Chairperson, the reality in the world today is that a few powerful nations think it is okay for only themselves to possess nuclear capacity. Today, the United States of America can willfully threaten to destroy sovereign nations such as North Korea and Iran if these countries refuse to dance to the tune set in Washington. In Europe, France, and the United Kingdom are recognized nuclear armed states, and the apartheid state of Israel also possesses nuclear arms. None of these states are being babysat. No stringent controls are imposed on them to ensure peaceful use of these dangerous weapons. Only few states have voluntarily stopped their nuclear arms programs, and that includes ourselves. Whether this was a right decision or not, only history would judge. We, however, believe that that world was not ready to have a state led by Black people presiding over nuclear arms. It is the only plausible reason South Africa was coerced into stopping its nuclear arms program. While South Africa and the rest of the African continent have taken a step back from these nuclear arms programs, the rest of the world continues taking our African minerals in order to enrich their nuclear arms program. We know for a fact that the uranium used to make atomic bomb dropped over Hiroshima was taken from Congo, while actual people doing the mining in the Congo were left destitute. Chairperson, We are of the view, therefore, that our approach to use of nuclear energy, whether peaceful or not, must be guided by our long-term objectives as African. We must adopt a pan-African approach to our conceptualization of nuclear energy in the 21st century. And we must do so in a manner that would empower African people, grow our economies, and protect African sovereignty. This agreement with the European Atomic Energy Community is a little out of place, therefore. Whatever agreements we make concerning the use of our nuclear capabilities must be driven by continental aspirations. Therefore, Chairperson, we reject this request. Thank you, Chair.
Thank you. ANC, and in the meantime, as the ANC comes over, Honorable Sheikh Imam, please mute your button there before you make the mistake I made the other day. Thank you very much, sir. Thank you.
Sorry.
Thank you very much, Honorable Deputy Speaker. South Africa has a developed nuclear energy industry, and this form of energy is playing an important role in the energy mix of our country. The country equally plays an important role in the international nuclear forums for peaceful uses of nuclear energy, such as the International Atomic Energy Agency. South Africa is internationally known for the development of nuclear medicine, which is critical in the health sector. This agreement reflects that South Africa has a responsible international role to play in the peaceful usage of nuclear energy. The ANC-led government supports the peaceful usage of nuclear technology and nuclear energy. The signing of the Euratom Agreement is part of and parcel of our international obligations to cooperate with other global partners in the nuclear sector for peaceful uses of nuclear energy. These multilateral forums allow the country to continue keeping abreast of international best practice through exchanges of cutting-edge information and developments in the nuclear industry. It, at the same time, ensures that the domestic nuclear industry follows best international forms and practice and stays abreast of latest international developments. This agreement is a bilateral agreement which regulates the relationship between European Union member countries and South Africa to conduct research, transfer of nuclear material and technology in accordance with international norms and standards of non-proliferation and ensuring the use of nuclear energy for peaceful means only. This agreement does not negate any other international obligations which both South Africa and Euratom subscribe to, such as the International Atomic Agency. On the contrary, this agreement upholds international agreements, norms, and standards for both parties who are signatories to it. The agreement does not include nor interfere with commercial aspects of nuclear energy for peaceful means, as it is a cooperation agreement which seeks to regulate the nuclear sector according to international norms and standards. It does not seek to make any market intervention. Its focus is more advancing research in the nuclear sector. This is important for South Africa as it ensures that the country is guided by the latest international research in all spheres of the nuclear industry. Research in nuclear medicine is a key area of growth of this sector in the country. Regulating technology and materials and the exchange thereof is crucial as part of the agreement, and these are based on international norms and standards. And for South Africa, it is important that our nuclear industry functions and operates within global norms and standards. The agreement regulates the transfer of nuclear material, technologies, and applications. This is critical as this is regulated globally and has to follow strict international standards for its successful operation. Key to this agreement in terms of the peaceful usage of nuclear technology is nuclear medicine and the application of nuclear technology in agriculture. The country already produces nuclear medicine, and this industrial activity is a growth industrial sector for local market and for export market, and therefore it is critical that we are in touch with the latest research and operate on best international practice for the success of the nuclear medicine industry. A critical component of the agreement is nuclear safety and ensuring that global safety standards are maintained in local nuclear facilities. Radioactive waste management and spent fuel management is a critical part of the agreement where information exchanges and new developments are important to the operation of the nuclear sector. Emergency preparedness and emergency responses at nuclear facilities forms part of the agreement, and here again it is imperative that local facilities have the best international practice for emergency preparedness and emergency responses. The legal framework for the agreement is based on South African law and the law of the European Union. Furthermore, this is coupled with international agreements and conventions of the International Atomic Energy Agency. South Africa is an important member of the International Atomic Energy Agency and follows all the international conventions. The Portfolio Committee of Mineral Resources and Energy has approved the signing of the Euratom Agreement. And this is another agreement or what we have to approve together with the DA for the first time in this committee. The African National Congress supports the Minister of Mineral Resources and Energy in signing the Euratom Agreement and urges the National Assembly to approve the agreement. I thank you very much.
Unmute yourself, Honorable Deputy Speaker.
Okay. Honorable members, I was saying that are there any members of the National Assembly who objects to the approval of the agreement between the government of the Republic of South Africa and the European Atomic Energy Community for cooperation in the peaceful uses of nuclear energy as it appears in the order paper? Any objections?
Yes, Deputy Speaker.
No objections.
Deputy Speaker, the EFF
Yes.
objected.
They will note the objections of the EFF.
Deputy Speaker, can you please note the objection of Al Jamaa?
Al Jama's objection will be noted too. Honorable members, having noted those objections, the agreement is agreed to. The Secretary will read the last order of the day. And members, remember that Honorable Buroto will take over from me after this to make a ruling. Thank you. Go ahead, Honorable the Secretary, please read the last order of the day.
Consideration of report of Portfolio Committee on Tourism on third and fourth quarter performance of Department of Tourism for 2019-2020.
Yeah. Honorable S.O.R. Mahuma Pilu, Buali Runara. Honorable Mahuma Pilu, unmute yourself and speak. Honorable Chief Whip, any assistance to Honorable Mahuma Pelu in the House?
Deputy Speaker, can I be afforded the opportunity to take the...
I'm here, Honorable Deputy Speaker.
Okay, go ahead, Daddy.
Yes, I got cut as soon as you were working on calling my name, Honorable Deputy Speaker. So my apologies for that. It was out of my control.
Sure.
Ke a go leboga modulasetulo ke dumedisa le seboka sotlhe sa kgotlatheo molao ya bosetšhaba. The essence of our report is based, among others, on the existence of single-mindedness in both the legislature and the executive branches of tourism responsibility. To this effect, we are single-minded in the long-term strategic goal of contributing to the achievement of a prosperous South Africa through tourism. We are conscious, Honorable Deputy Speaker, of the protracted nature of a necessary struggle between the embedded in economic comfort and the embedded in perpetual economic discomforts and suffocation. Conscious of these future generations should not only applaud our effort, but embrace such effort, build on it, and strengthen it. Part of the basic human effort the tourism sector is trying to pursue in contribution towards the necessary reduction and ultimate elimination of poverty, inequality, and unemployment is expressed in the following. 1, the employment of agents of necessary transition from bureaucratism to revocratism, the majority of whom are women, which the committee is satisfied with. Achievement of 82% of the set agreed targets in the annual performance plan. 3, necessary shifting of the economic pendulum towards the economies of the villages, the townships, and the small dorps. 4, introduction of 200 million rand of the Tourism Relief Fund, mindful of the reality that financial resources are inherently characterized by scarcity. 5, improvement in the audit outcomes from qualified to unqualified. 6, South African tourism unqualified with material findings according to the Auditor General. 7, commitment and practical action to deal with the AG's audit matters as raised. 8, concomitantly, a commitment to continue with the intensification of the consequence management against those whose actions result either in wasteful, fruitless, irregular expenditure. 9, vigilant response to the COVID-19 pandemic is appreciated by the committee. 10, continuation of the work in implementation with the CAF-SITA and all other bodies relevant in this regard. 11, the institutionalization of work with other 18 relevant departments linked to tourism. 12, more collaboration with the private sector in deepening tourism economic growth. 13, more collaboration with DERCO and other departments on matters that relate to tourism in as far as the international sphere is concerned. 14, the intensification and deepening of tourism transformation in the context of building a non-racial, non-sexist, and a prosperous society. Deputy Speaker, we thank you for understanding that no human effort is effortless. Yalebo.
Deputy Speaker? Okay. Can we have the EFF? I mean, sorry. Is he there? Okay. All right. There are parties that are wishing to make a declaration after the report given by the Chairperson of Tourism, Honorable Mahuma Pelu. May I invite the DA?
Okay, all right.
Oh, he's back. Deputy Speaker, we were calling on the member of the DA to make declarations if they are.
I did hear, except that my guidance was suggesting that we should ask the Chief Whip
Okay.
first to indicate what they want us to do with the report.
Can you proceed, Deputy Speaker? Thank you.
I am. Chief Whip.
Thank you, Deputy Speaker. Deputy Speaker, I move that the report be adopted by the House. Thank you.
Thank you. We now give the opportunity to parties wishing to make a declaration. The DA. The EFF.
Honorable Deputy Speaker.
Yes.
Honorable Deputy Speaker, in comparison to many other...
Are you from the DA? Is that...
Yes, Honorable Deputy Speaker.
Okay, go ahead, Daddy. Go ahead.
Honorable Deputy Speaker, in comparison to many other departments, the Department of Tourism performs better. Objectively, it's not collapsing in controversy and scandal, in any major financial mismanagement, and in the hollowing of its own capacity. The question is, however, are we measuring its performance correctly? It is, after all, not a service delivery heavy department, and ultimately its performance is largely dependent on the success of other departments and municipalities. So to get to the point, the performance of the tourism department should be measured by the minister's ability to do two things. One is to support tourism businesses to grow and create jobs by making entrepreneurs' lives easier. And secondly, is to influence other government departments that they need in order for tourism to be able to grow and to do their job better in driving up tourism numbers. This is the crux of meaningfully measuring the performance of this department. And so how does the minister do on both those fronts? In supporting businesses, the department has still not effectively made a move towards free grading services for places of accommodation. Although this has been constantly pushed and initiated by the DA, this is supported by all political parties in the Portfolio Committee and was again emphasized this morning in Portfolio. So why does the minister continue to delay this? Why has she not entered a plan to move towards free grading? When does she commit to making grading compulsory but free of charge so that we can empower the many businesses out there that are wanting to get into the services space for accommodation and employ more people in the sector? In a webinar with the Tourism Business Council of South Africa, there was mention of the establishment of a public-private sector steering committee towards the recovery of the sector's post-COVID-19 plan. This would be good news to have a champion for all those businesses that have been decimated in this period. What business costs, but what are the terms of reference of this committee? What has this committee actually ultimately achieved? What business costs or regulations have they removed so that those struggling businesses have a path to profitability? I worry that the results are less favorable. The second area is how the minister influences other government departments to improve tourism in South Africa. For some time, the DA committee has spoken about making it more affordable for tourists to fly to South Africa by doing everything possible to reduce the cost of traveling to the country. This was backed up at a recent portfolio committee with the Board of Airline Representatives of South Africa. But what has been the minister's influence on this front? Seemingly nothing, as costs continue to skyrocket. Nothing, however, screams a lack of influence when it matters, like the collapse of tourism in the Howick Falls area in KZN. What was once a beautiful local attraction, with many tourist buses near the Nelson Mandela capture site in inner KZN, has collapsed due to the failure of government on multiple fronts. The police have failed to keep the area safe and secure. The municipality fails to keep the area clean and even simply collects garbage. The street lights aren't replaced, and the area continues to have a collapse in water and electricity supply. And even after the portfolio committee visited the area, demanding answers from government, it took nearly a year to get a report just to find out what was going on and how it was going to be improved. This is a clear indication of the collapse of the ANC government and the lack of influence, not only of the portfolio committee, but of the Minister of Tourism to affect any real and meaningful change in the area through SAPS or the municipality in a way in which improves the ability of the Department of Tourism to get its own outcomes. And so, whilst it is easy to self-congratulate the performance of the department on a largely meaningless criteria, which has not fundamentally changed the lives of many people who are hopelessly languishing in unemployment, our job is to hold the government to account and to be the alternative, to actually help business to succeed and to get tourism numbers on the rise. And on that front, the Minister of Tourism is lacking. Thank you very much.
The EFF.
Thank you, Deputy Speaker. Deputy Speaker, we won't be doing a declaration on this order because according to the order paper that we have received, the last order was the mineral resources one. So if by any chance this was swept in, we didn't see it, and we right to raise our objection on it, Deputy Speaker, because we didn't see it. So we won't be making a declaration on it, and we'd like to express our disappointment in this regard. Thank you.
Deputy Speaker, I rise on a point of order.
Okay. Yes, what's the point of order?
Deputy Speaker, I rise on a point of order to say that all chief whips of all parties were informed this afternoon, just past 1 o'clock, that there'd been an error made on the order paper. The order paper was then withdrawn and the correct order paper was redistributed. It was done so to all chief whips, and it was also done so on the actual programme of Parliament. And all chief whips who are on the Chief Whips Forum group were also informed accordingly, and therefore everyone knew that there had been an error and that the error had been immediately rectified.
Okay.
On a
thank you
point
very
of
much.
order, Chairperson, to the class prefect. On a point of order to a class prefect, we won't be liable on such errors. It needs to be sent on time. If she wants to tick the box because she's a class prefect, not here. Let's meet in Brackenfell.
Honourable Member, you are out of order. This tendency to name and call people names is irresponsible and out of order. You don't do that. Go ahead, Honourable Member of the IFP.
Thank you, Honourable Deputy Speaker. Fiscal transparency and accountability are the fundament of good and clean governance, and simply cannot be overstated. They are the rudiment of well-functioning democratic state. Turning a blind eye to electoral expenditure, nepotism, corruptions, and maladministration in department programs during the novel coronavirus pandemic is bad for the department. It has serious consequences on livelihood of people working in tourism sector. The committee noted its satisfaction with the level of transparency with which the department conducted its third and fourth quarter performance report. Yet, the department casually reported that at the end of financial year, the department had 496 employees against the head count target of 471. It resulted in a vacance of 25 without much detail to how this happened. This is a huge issue as it allows for possibility of ghost employees. Irregular expenditure makes us the part of government maladministrations. The department has reported difference in how many people were employed against the physically head count. This is professionally concerning as it flagged a possibility of ghost employees who are either people benefiting from not doing work or, as with the past, indicate maladministration of public fund evidence. This brings into question the department hiring processes. The IFP called for the minister to answer to the department why is looting public funds and why no attempt have been made to ensure that the department does not exceed its target. Furthermore, the department reported that it's used 99.7% of its allocated budget and achieved only 76% of its target. Why did the impact of COVID-19 as contributing factors to the non-achievement of this, the impact of the contribution factor to the non-achievement of the same quarter 3 and quarter 4 target is unacceptable reason, hiding behind COVID-19 for lack of achievement, that on issues that have been prevalent in previous target. It is an unacceptable reason why behind COVID-19 for lack of achievement that on issues that have been prevalent in previous engagement. Profitable shame and reflect badly on department ability to be transparent. Take the responsibility and be accountable. But the IFP do support support and accept the report. Thank you very much, Deputy Speaker.
Thank you, Honourable Member. Freedom Front Plus. ACDP.
Chair, we were duly advised of the change of program, but we won't be making a declaration. I thank you.
Thank you. UDM, ATM, good, NFP, AIC, COPE.
Thank you, Deputy Speaker. We know the report. Thank you very much.
Thank you. PAC, Al-Jama.
Al-Jama, Deputy Speaker, supports the report. We note the enthusiasm of the chairman of the Portfolio Committee, especially his efforts to get a unqualified audit. However, we feel that the department should spend some time and budget resources for more events all over the country. And we feel that if that happens, this will be a concrete way of showing support for the tourism industry. Thank you very much.
Thank you, Honourable Member. ANC.
Thank you, Deputy Speaker. Deputy Speaker, honourable members of the National Assembly, greetings to you all. Deputy Speaker, the ANC supports the performance report on the third and fourth quarter performance of the Department of Tourism, as introduced by the chairperson of the committee, Honourable S.O.R. Mahumapilo, before this august House. The tabling of this report, Deputy Speaker, comes at a right time, immediately after the people of South Africa had again showed confidence in the African National Congress during the 95 by-elections that were held on the 11th of November countrywide, where the ANC recorded not less than 70% of support overall. I thank the electorate for such support to the African National Congress. Deputy Speaker, the report before this House is a reflection on the performance of the Department of Tourism that we oversee as a committee for its third and fourth quarter performance of 2019-2020 financial year. As a committee, we robustly engaged the department during presentations and agreed on this report. We observed that the department is responding positively to the President's call, as outlined in the SONA, of doubling the numbers of international tourist arrivals to 21 million by 2030. Also observing that the department displays commitment in developing and implementing policies that talk to the strategic objectives of the country, that of job creation, that of addressing historical imbalances, that of paying special focus to rural provinces, including small towns like Port St. John's in the Eastern Cape. Their performance report, amongst other things, talks to the development of a national tourism information and monitoring system, provision of funding for signage to 5 national parks, skills development and empowerment of small enterprises and other activities under various programs as highlighted in the report. Deputy Chairperson, it is encouraging to oversee a department that reports not only on achievement, but also on shortfalls, and ready to account, also taking responsibility and accounting on targets that are not met. An example is when the department had a target of creating 1,517 full-time equivalent jobs, but instead of them accounting for that number, they accounted for 1,255. Amongst the reasons given to the committee was the impact of COVID-19 pandemic, which lastly resulted in the country being placed under national lockdown to curb the spread of the virus. Both international and domestic travels were affected, and that led to some of the departments being postponed and later cancelled. As a committee, we observed a number of initiatives from the National Command Council because of the disaster that was declared by the President. We observed the establishment of a tourism relief fund. A budget of 200 million was set aside, and businesses were all influenced to apply from that fund. That was done to make interventions into saving jobs. Generally, Deputy Speaker, the performance report was accepted in the committee. On behalf of the ANC, I am of the view that this report be considered by this House. Diabulela Segela Somlo.
Thank you very much, Honorable Member. In other words, you agree with the motion of the Chief Whip that the report be adopted. Are there any objections, Honorable Members? No objections, agreed to. Honorable Members, I hand over to Honorable Buroto to complete the proceedings of the House. Honorable Buroto.
Thank you, Deputy Speaker. Honorable Members, on the 1st of September 2020, during the debate on the recent scourge of farm attacks in South Africa, the Honorable C.N. Mkhonto said, "The right-wingers and those who are hell-bent on maintaining their colonial ill-gotten wealth by all means possible, the DA is part of this grouping of white racists. In response to the remarks, the Chief Whip of the Democratic Alliance rose on a point of order to contend that it was unparliamentary to cast aspersions on members of the House or refer to people in a derogatory way at the time. At the time, I ruled that Honorable Mkhonto was not referring to a specific member, but rather a political party, and as such, her remarks were not unparliamentary, and they were in order. I nevertheless indicated that I would study the record and revert to the House to clarify my ruling. This is unusual, honorable members, but we had to do it so that it is able to assist us going forward. Having had an opportunity to review the record, I wish to state as follows. Firstly, I must refer to Section 58 of the Constitution, which provides for parliamentary privileges. It states that members of the National Assembly has a freedom of speech in the Assembly and its committees, subject to its rules and orders. The rules themselves ensure that parliamentary proceedings can be conducted in an orderly manner and respectful manner, but they must be interpreted to place the fewest limitations on free speech. This standard, honorable members, has been reinforced by the courts in 2015. The Supreme Court held that while Parliament may be empowered to make rules, its rules must be interpreted in conformity with the crucial guarantee of freedom of speech in Parliament afforded by Section 58(1) of the Constitution. That right is necessary incident of representative government in a democratic society. In the context of the Constitution, the rules necessarily prevent members from, among other things, using offensive language or imputing improper motives to the other members. They do not, however, prohibit members from criticizing or even maligning others. That is, those not specifically protected by the rules. This would, as the Supreme Court declared in the same case I have quoted, include references to the government and political parties in general. Such a prohibition would infringe free speech. Indeed, presiding officers have consistently interpreted the constitutions and rules in this manner. On the 15th of September 1998, the Speaker then, Dr. Ginwala, stated that we have always drawn a distinction between allegations against members of the House and the expression of opinions about the beliefs and policies of political parties. Accordingly, references to a member as a racist have been held to be unparliamentary. Allegations that a political party supports racist views or has or is implementing racist policies are made frequently and have not been held to be unparliamentary. They are, in my view, a part of normal political discourse, and any attempt to limit this would set a dangerous precedent. Concerning the proceedings in question, it is clear from the record that Mr. Mkhonto was not referring to a specific member or even members of the House, but a political party in general. It was for this reason I allowed her to continue. Notwithstanding what I have said, I must also comment on the role of Parliament must play in our society. We come from an exclusionary past, a past where our people were set against each other. As members of a democratic parliament, we must be passionate and robust in confronting the social ills, but we must also show respect and restraint. In this regard, we must be mindful of references, although not made in relation to an individual member, but are in themselves inflammatory and divisive. I trust, honorable members, that this ruling clarifies the matter and the prevailing precedent. That is the conclusion of my ruling. Honorable members, the other ruling I won't make because I inquired about the members if they are on the platform, but one of the members is not on the platform. As such, I will privately talk to the chief whips of the members involved so that I will do the ruling when they are on the platform. Honorable members, having said that, the honorable members concludes the business of the day and the House is adjourned. Thank you very much.
Forward.